This hearing is in regards to case number CFI 030-2022 before Justice Sir Jeremy Cooke. The claimant is represented by Norton Rose Fulbright Middle East LLP. Lead counsel is Mr. Tom Montague Smith KC. The first defendant is represented by Diana Hamad, attorneys at law. Lead counsel is Mr. Tim Taylor KC, assisted by Mr. Jonathan Chu.
Right, very good. Mr. Taylor, you were just explaining your position.
Thank you very much, Your Honour. So there were three relatively minor housekeeping points, I hope relatively minor, is that I ceased to be retired from KWM on the 31st of July. I'm currently supposed to be taking a sabbatical. I am in the process of migrating my Part 2 registration. I think it is showing as pending on the system. So I'm instructed by Diana Hamad advocates as Part 1 representatives. I'm here as a Part 2 representative. I think it's shown as pending in the system, still linked to King & Wood Malleson's MENA LLP. And I believe that I have to ask permission, Your Honour, on the basis that it's pending.
Right, I'd wondered what the position was. Yes, I can't think of any reason why there should be any objection to that. Can you, Mr. Montague Smith? We know Mr. Taylor.
Yes, quite. No objection from here.
Very good.
Thank you, Your Honour. The two other, even more minor housekeeping points is that my skeleton argument would be inconclusive. The conclusion has slipped onto the 26th page, and I couldn't cut out when the references went in. I couldn't cut out any more of the quotations of Justice Wayne Martin without him saying that he was putting things in yet another way without them having been put in at least one way first. So if I could have permission to go that tiny bit over the page limit.
Yeah, you could have cut out some of your literary quotes and some of your biblical quotes which are out of context. But leaving that aside, yes, you have permission to go over 25 pages.
Thank you, Your Honour. And the last thing is just a citation. There is an article by Professor Andrew Dickinson, which is at Divider 143, page 4058, the bundle, and Norton Rose Fulbright, who've been extremely helpful in the bundling, etc., couldn't find a reference. Professor Dickinson tells me it's 2019 135 Law Quarterly Review at 294.
Thank you. All
So,
right.
Your Honour, that was the housekeeping. In terms of the order of batting, first, Your Honour, did my two skeletons, one for the RDC 12, well, the third being the preliminary outline submissions, in which I accept that a certain amount of ventriloquy may have been detected, but my client was at pains to point out that I was there and didn't want to be accused of gaming the system, as some other litigants have in the past. So I'm glad you've got those, because I think that's, as far as I'm concerned, with my learned friends reading this, is the good starter back. Has Your Honour had an opportunity to glance at the permission, the second defendant's permission applications, which are in the bundle?
Not really, no.
No. Well, I mean, just two matters arising out of that. I mean, they're somewhat turgid. They're nearly 200 pages, but they're there for two reasons. One, very simply, is that in the application number 9, directions are, in one of the applications, directions are sought for how to deal with permission applications on appeal. That's the primary reason that they're in there. What they also do in terms of the affidavit of Mohammed Kayali, which is at Divider 54, pages 1522 to 26, and in his exhibit MAC 1 at 1527 to 1597, is that they give some update on what has been going on shore since the matter rested, I think, in what my learned friend's clients had put in, which was the judgment of Ahmed Fathi Kama, which is at 2724 to 2726. So, Your Honour, I was not, I suspect my learned friend's point of departure will be that the JJC stay is now hopeless, that the conflict requirement is not met, and that, etc., etc. I was, the first defendant's position, Your Honour, will be that so far as the JJC is concerned, that the timing requirement with respect to which Justice Ali Al-Madani, His Excellency Justice Ali Al-Madani, set aside the stay is now met, and that if upon determining that the court does have jurisdiction, because Your Honour, you will have seen, I don't put it under 12.1.1 that the court doesn't have jurisdiction, I put it under 12.1.2, is that you would have to stay anyway under Lacan. And in Lacan, as Your Honour may recall, it was accepted that when it was remitted to first instance, that if the defendant was unsuccessful in his jurisdiction challenge, then it would have to be stayed anyway. Now, that is where we say we are, but my primary position, Your Honour, is that to an extent, even though the JJC stay is now right and mandatory, is that what I primarily submit is that for the remaining grounds, the JJC ground is on a ground 1 of 5 in my skeleton, but for the remaining reasons, it would be much better for this court, in effect, to resolve the conflict by sending the claimant off to the proper court. So that's where we are. Your Honour, what I was going to do is just suggest a running order and see if it works for Your Honour. My learned friend and I have agreed that clearly privacy would come first at the outset. I was proposing to leave ADR to the very end. And I think my learned friend and I are also agreed that the running order, notwithstanding that he's got an extension of, or is that he's saying I'm out of time and need an extension, should be what I compendiously call the stay applications. In other words, all 5 grounds in my skeleton, JJC, the abuse public policy, and the case management grounds, which I've lumped under Rule 12 and the general case management powers, that would go first, and that immediate judgment he would open in responding to that. If that's acceptable to Your Honour as a running order, the way in which I had proposed to approach the stay grounds was to begin, Your Honour, by...
There's another way of looking at it, which is that the immediate judgment should simply be granted on the basis that there is no defence, because in itself that doesn't impact on how the judgment is going to be executed, which is your issue.
Well, Your Honour, what I say about that is 2 things. First of all, that it's wrong in principle, because if I am correct on the JJC stay, then the timing requirement, which was the basis and essentially the sole basis on which Justice Ali Al-Madani set aside the stay that had been imposed on the 29th of June by Justice Mera Al-Mehri is that the timing requirement is that this application needed to come on, assuming it's not out of time for the moment, that if the court concludes that it does have jurisdiction, then even if it were minded to go on to exercise it, is that it should stay the proceeding immediately. And as I put it in relation to the entry of judgment, is that whilst there may be some minor sort of case management advantages to entering the judgment and then staying execution, that this is properly categorized as primarily a case of pending proceedings where there is a risk of conflicting judgments, subject only to the fact that I would say that the dividend freeze, which prevents the dividends from the shares in the restaurant being used to fund the alimony and maintenance, is an existing conflict of a judgment between the family court, the personal status court judgment. And
that's the question of the freezing injunction, though. I mean, your conflict relates to execution over the shares. So we could deal with that in due course. But on the face of it, it seems to me there's no good reason why judgment shouldn't be entered.
Well, Your Honour, I say that there is, and essentially...
Sorry, I lost the judge there briefly. I do apologise for interrupting. You've frozen, my lord, so I thought we might have missed the end of your sentence.
Well, I don't think you missed very much, but I was simply saying that I saw no reason why judgment shouldn't be entered, because the only potential conflict arises in relation to execution on a particular bunch of shares. And on the face of it, you're entitled to a judgment that recognises the English court judgment, whether or not there are any assets in the jurisdiction that are capable of having execution levied against them. Mr. Taylor says, well, there's a potential conflict and that's enough.
Well, Your Honour, yes. I mean, I accept, of course, that there is no necessity for there to be any assets present in the jurisdiction for the purposes of a judgment being executable. And this, of course, is not the issue here is at the opposite end of the spectrum, which is that the only asset which is in play is the DIFC restaurant, which is owned by a DIFC registered entity. And the only purpose for which they're seeking a judgment, on the, I believe, Lord Collins described in Rubin and Eurofinance as the fiction of there being an obligation from the point of common law. The only reason that they're doing it is to get hold of the shares, and that consistently with the properly purposive approach that was articulated in 5, basically following on from Lacan, is that to use the words of His Honour Justice Martin, is that when you look at the 2 vices the Joint Judicial Committee is to be targeting, one is concurrent conflicting cases, and the other is conflicting judgments. I agree with Your Honour, you're absolutely right, that the only element of an existing conflicting judgment is the freezing order. On the face of it, there is simply there being a judgment debt from the first defendant doesn't in of itself conflict with anything. But where Justice Martin says that, where there are circumstances which create a significant risk of inconsistent judgment, which burdens the parties, is that you should not slice and dice the issues that are looked there. You look at it in a broad, holistic, and purposive way, and you're bound to stay. So Obviously, my learned friend is focusing on the money judgment being separate and distinct, but I think that's an artificial way of looking at it, and that furthermore does have a practical consequence potentially, which is that, in my respectful submission, unless and until the English judgment is recognised in the courts, either onshore or offshore, there is, so far as my client's solvency in the UAE, where he's resident and under the bankruptcy law here, obviously the question of whether he is meeting his obligations as they fall due, I would, it's not a matter of research at great length, but it seems entirely logical that an unrecognised, as yet unrecognised and unenforced judgment is not an obligation that is recognised under municipal law here as due and payable, whereas the moment that there is a judgment debt, the fact that execution of it is stayed would not prevent him from being unable to meet his obligations as they fall due. So, in my respectful submission, Your Honour, to enter judgment and then stay execution would be wrong in principle, because the material vice which brings down the JJC stay is the conflicting progress of two sets of proceedings onshore where negative declarations are being sought and persisted. Yes, I appreciate that they've been kicked out at first instance, but there are appeals, and my client is seeking a review of that decision because they didn't address his counterclaim. But the substance of it is that they're seeking negative declarations with respect to the ownership of the shares, to say that they do belong to the second defendant and her two children with my client, and that they don't belong to my client. And the very thinly pleaded trust claims in the points of claim are to the exact opposite effect. And Your Honour, in terms of the DIFC courts, in my respectful submission, retrieving their powers of flexible case management, it does make a great deal of sense to avoid there having to be litigation in sister courts in Dubai, when, if Your Honour, you were to enter judgment and then proceed with the second part, I accept that it only arises when you get to dealing with the other relief beyond immediate judgment, is that the most that you could hope to produce is a judgment that says that these shares belong to my client, and that would be a conflicting judgment with the family court judgment, subject to a learned friend wanting to say that it's only an agreement. So there'll be another conflict to go back to the JJC. And why? My respectful submission, because I do say that there are very, very strong grounds not to proceed with what Your Honour said, execution of the money judgment. But is it really execution, Your Honour? In the sense that what they're seeking to do is to, in substantive proceedings, not by way of execution, in substantive proceedings, they're trying to get a declaration that assets that a Dubai court of competent jurisdiction, and I would say exclusive jurisdiction with respect to division of matrimonial property and the custody of minors and their care, etc., has made a final judgment. And that's not, they're not seeking that by way of execution. If my learned friend, Mr. Montague Smith, gets to to the outcome that he dangled in front of Lord Angus Glennie, he would be getting to appoint a receiver. Now, at that point, you may be in execution, but this is a substantive claim seeking a declaration of trust, and that these shares belong to Axel Mannes, the first defendant, where there is a judgment which has been executed, I say ministerially only, in the TIFC, which has transferred those shares to Catherine Ziller, the first defendant, and her two minor children, who are hiding in plain sight on the register. So, in my respectful submission, Your Honour, it's an oversimplification to say that goes straight into execution, having recognised and enforced the money judgment, because you wouldn't be executing that money judgment. You'd be taking substantive proceedings based on a proprietary claim. I mean, it'd be different if they were making a monetary claim, not encouraging them to do so. But this is, it's alleging a proprietary base directly inflicted.
You're right in saying that one shouldn't simply describe it as execution, because the particulars of claim have two elements to them, one of which is simply recognition and enforcement of the judgment in paragraphs 1 to 5 of the prayer for relief, and the second is the declaration of the beneficial ownership, which is in 6 and 7. I understand that, but the point still holds good that I can't see any reason at all why judgment shouldn't be given. And if that makes your client bankrupt, it makes your client bankrupt. It's as simple as that. That seems to me to be a beginning and end of the judgment issue. And I don't really, unless you've got anything further to say, need to explain any further.
I won't press it further, other than to say is that my point is that the proper approach should not be the sort of inductive common law approach, but a top-down purposive approach. What on earth are they trying to get this judgment to do? They're trying to get
I understand.
get that on their share.
I understand the point.
I won't press it further, Your Honour.
I understand the point. Now, it seems to me it's quite plain that the court ought to recognise the English judgment. There's no reason not to. And in terms of paragraphs 1, 2, 3, 4, well, we'll leave the interest aside for the moment in case there are any arguments that run on interest. But 1, 2, and 3 of the prayer for relief, the court should recognise, and a judgment will be given accordingly. We'll deal with interest at a later stage. Having said that, I think the right thing to do is for you to deal with your privacy application. And then we'll decide where we're going from there, because I want to know exactly what points are still being run. As I understand it, and tell me if I've got it wrong, Mr. Taylor, you're not running any point about irregularity in service. You're not running any point under 12.1.1 saying the court has no jurisdiction. You've accepted that. It's a question of whether or not the court should exercise jurisdiction. Have I understood that correctly?
Subject to one reservation, Your Honour, which is that whilst I accept that the court does have jurisdiction, and this couldn't properly be a 12.1.1 point, is that when I take Your Honour through the procedural history, which I was going to say, I was going to begin with that, because if you're with me, Your Honour, it is my case that I don't need any extension of time. And if you're with me on that, then the whole question of whether relief against sanctions is needed, and whether it should be the Denton test, doesn't arise. But what in relation to what I need to at least preserve the right to do, is that if all else fails, I would need to preserve, for appellate purposes, the argument upon which what I will show you, Honour, because I mean the procedural history in this is, I looked at it and I said, what would Buddha do? And then I said, what would David Byrd do? probably only you and I remember David Bird, but it's a difficult procedural history. But the key
You
point.
often have a drink.
I'm not even sure if he's still with us. He's invisible on Google, but I hope he is. No. No, Your Honour, is that what I will show you in going through that is that there was an explicit Rule 12 application made in 021, which is the Part 8 claim, which appears, unless my learned friend tells me something different, appears not to have been dealt with at all in either the stay decision of Justice Maha Al-Meri on the 29th of June, or in the set-aside application, which my learned friend argued and prevailed upon in front of Justice Ali Al-Madani. Now, so I need the substance of what was being the gravamen of that jurisdiction challenge was to seek to set aside service on the basis that alternative service should not have been given. I fear that I do need to, even though I'm not going to press it, I do need to preserve that point for appellate purposes because of service having been affected under. Well, there are 2 points, Ron. Sorry if I'm going on this. Is that there is the question of whether it is permissible to for the DIFC to order alternative service, and so far as that is concerned, even without getting to the rather sophisticated reasoning whereby Justice Richard Field has said that the service provisions of the Riyadh Convention, even though mandatory, don't apply, is that the UK-UAE service there are several cases that have said that is essentially not mandatory, and in the commercial court in London, certainly alternative service is granted almost as a matter of course whenever there's a without notice freezing. Yeah. Now here, I hope that I have to go nowhere near this, but what I have to preserve for appeal is that Decree 57 of 2018, which purported to change the service arrangements under the Civil Procedures Code, is entirely unconstitutional. It's a ministerial regulation that purports to amend primary legislation, which has gone through the Legislative Council and been implemented in Dubai. And so there is a point there, but I don't want to go anywhere other than preserving it. I don't want to have to go anywhere near it because I don't.
Well, I'll tell you what I'll do, Mr. Taylor. Yeah. Why don't I make a very quick ruling on that, and then you can appeal against that if you need to.
So that ruling would be that.
The ruling would be
to dismiss that element of the set-aside application.
That there has been proper service, and then you can appeal against that if you feel that that's something you wish to do, subject to you getting permission, I suppose.
Yeah, I think.
Yes.
I
think that's the neatest.
There may be more optimistic grounds, Ron, but there we are. Yeah, and I think that makes entire sense.
I otherwise had it in mind to cover the point in any event as being one that had been abandoned. So let me just say this. A point has been previously taken by the first defendant, which is that there was no proper service on the first defendant of the Part 8 claim for the freezing order. In my judgment, that is misconceived. There was service in onshore Dubai of proceedings, which is governed by RDC section 1 of Part 9, RDC 9.1. Alternative service was effected in accordance with RDC 9.31. There was good reason for alternative service here, as the first defendant had been evasive, as can be seen from all the matters referred to in the claimant skeleton, paragraph 48, subparagraph 2. He's still given no proper address for service in Dubai, only a post office box number and a district in Dubai for his address. In those circumstances, I have no doubt that in accordance with a welter of authority, there was proper service on the first defendants of the Part 8 claim for the freezing order or its continuance. In those circumstances, I've made this ruling to retain the possibility of preserving the point for argument elsewhere. Does that cover the ground, Mr. Taylor?
Your Honour, I'm grateful. I know there may be a timing issue as to when the address was provided. That I believe that my client, that the address that he gives on his witness statements is a real place. But be that as may, no, there's nothing arising.
Just to correct that, he currently gives a shopping mall in Al Barsha as his address.
Well, there we are. Let's leave that point for further debate, should it ever become necessary.
Well, I'm grateful.
All right.
I don't want to have to
That's
go
okay. I understand your position.
Still less did I want to have to get permission to withdraw a concession.
No. I understand that. Should we deal with privacy first then, because that's logically the best place, the first place to go, I think.
Absolutely, Your Honour. And what I say in relation to privacy is, first of all, the course that I'm inviting Your Honour to take, given that this is an online hearing, is in the first instance a distinction without a difference, because we're being recorded on YouTube. There's a transcript. Yeah. Maybe there's a door somewhere in cyberspace where you can say sitting in private. But what I'm inviting Your Honour to do is, in essence, to consider after the event whether there is anything which ought to not get out into the public domain. There are, I mean, I don't think I need to trouble Your Honour with the starting point that proceedings need to be in public. There are two perfectly uncontroversial exceptions in Part 35 RDC 35.4. I think it's subparagraphs 1, 3, 4, and 7 if we need to look at them. But in terms of subject matter, one thing is interests of minors, which are engaged here. My learned friend had said, when applying ex parte of the freezing order to Justice Lord Angus Glennie, that the children can be joined if need be. And he was speaking then prospectively to that was the Part 8 claim back in March 22. And when my learned friend said the children can be joined if need be, he was referring to the as yet unborn 030 of 2022, which is the Part 7 claim. Now, as Your Honour has seen, the children aren't parties to that, but their welfare, custody, etc., will be some subject of discussion. Frankly, I don't think it has been much, and it may be necessary to redact bits of a transcript for that. No question of suggesting that there should be any anonymisation of the parties or spare the registry from either alphabet soup or further alliterative fake names. None of that. But the point of substance really is more to do with the ADR application. Because, Your Honour, I mean, I note that in my learned friend's skeleton, for this hearing, he's said, paragraph 11 sub 5, you don't need to look at it, it's a very short statement. Whilst claimant is always open to hear offers as to how D1 intends to settle the English judgment, D1 needs to make a concrete written proposal. He then goes on to say something he has so far failed to do. Now, Your Honour, I think the only concrete proposal I've ever had was a death threat, but that's neither here nor there. The point is that how could he answer whether or not he has made a proposal, concrete or otherwise, without straying into a privileged area? So it's really what the course, in fact, that I would invite Your Honour to take instructions is to, if you would prefer to proceed with the stay applications, as I shall refer compendiously to the RDC 12 and the immediate judgment in open court, and then sort of go into private for the ADR, I think I would be content with that, because it, it does involve, without prejudice, privilege, and potentially the rather elusive concept of a mediation privilege that is separate and apart from the parties. This, I forget what it's called, pharmacist 2 or something, where I think Justice Briggs has tried to develop the fact that the mediator himself has rights of confidence in the process. So that's the reason to keep it under wraps, because
the court never enters into that in making orders for mediation in any event. I mean, you can't be revealing WP offers to me.
Well, no, not unless. But I mean, this is why I make the point about what I think there would be a point of view that when my learned friend has said you haven't made any offers, that I should be able to gainsay that if that's the case. The last thing I want to do is be a witness and there's no evidence before you. But look, Your Honour,
I'm not very interested in that. That doesn't seem to me to advance the matter one way or the other, to be frank. Let's proceed then with the stay application, and when we get to any question of mediation, you can raise the point. But I tell you, Mr. Taylor, at first blush, I can't see any basis upon which there's any need whatsoever to protect the interests of any child in this. The children's interests are entirely derivative on the question of whether the mother held the property as nominee or as trustee for the father. And so there's no reason for the children to be the subject of any mention beyond the fact that they are now 33% shareholders each as a result of a transfer from their mother. Beginning and end of point, isn't it?
No, Your Honour. Look, I'm not going to press the privacy point further, because if that's where Your Honour is minded to go, then so be it. I'm not going to press it further. But again, in my respectful submission, Your Honour has jumped out an essential stage in the process, which is that to just say the issue is whether they belong beneficially to the father and whether he has transferred them to his ex-wife and their 2 minor children, is again conflating 2 things, because the case that is put by my learned friend is that the point at which the claimant alleges that the first defendant divested himself of the beneficial interest in the Dubai restaurant was back in 2020, when the shares were transferred to a Jebel Ali Free Zone entity called 5 Aces.
I've got that point.
On the register. So my point is that what has intervened to effect the transfer has been what my learned friend unsurprisingly calls the divorce settlement agreement, and I'm calling the divorce judgment, because when one looks at, as I would take Your Honour to, on a admittedly somewhat a basis of cursory review, the Law 8 of 2005, which is the personal status law, is that what I will submit is that this is a court that has exclusive jurisdiction, and that it has divided up the matrimonial estate and has ordered it, in a system of law where there isn't a concept of divided beneficial and legal ownership. It has adjudged that these shares belong to the children and the ex-wife, and that the dividends are to fund my client's obligations to pay maintenance, as to which there are extremely serious consequences here if you don't pay it. The back end of Decree 57, I think over a third of it is to do with execution of judgments and imprisonment for debt. There's a prima facie exception to be put into Cooke for owing money to your ascendants and family members, but it doesn't count for alimony. It's taken very seriously. Now, that's, whilst it is true to say that so far as the dividend income is concerned, where what we've got is an existing conflict of judgments between the divorce judgment, which I'll take your honour to, and you'll see it was to fund, the dividends were to fund alimony, education and maintenance. That's what it was there for. That's the income bit of it. What the learned friend's client is attacking in the balance of the points of claim is the proprietary interest. So to say that, oh look, it's all that's going on here is that they're trying to reverse something cooked up between the first defendant and his ex-wife, and for which the kids were, mere ciphers. Bizarrely, there's under DIFC law, you have a responsibility from the age of 7, I believe. Under DIFC law, I think it's somewhere in the law of obligations, but that misses out the essential intervening step, which is indeed the core of my my collateral attack argument, and in principle identical to what Your Honour found in the Hague case, where, if Your Honour recalls, in the David Hague case, you gave an extempore judgment, and you wouldn't let him make claims for, I think, 2 species of tort that Mr. Montague, my learned friend, has since had knocked on the head as not existing under the obligations law, because you said it was an unacceptable end run around the criminal court's bail conditions. Now, that is joining up the dots between the Birmingham 4 or 7 case, or whatever it is, Hunter in the House of Lords, which is the locus classicus on abuse, and when is it a collateral attack? So what I'm saying is that this is the claim. The trust claim is a proprietary claim which can only produce a conflicting final judgment, conflicting with local court's judgment to go back to the JJC, and that it is abusive because if they're saying that this judgment in the Dubai courts, the personal status courts, was obtained by fraud, and they may try to say that they're not really saying that, but I mean, I can take Your Honour to what my learned friend was saying, at the ex parte stage, when, to be fair, he had not seen the divorce judgment, is that that's what they're saying, and all
of that. But where are we going to, Justice President? I'm trying to find out where you're going.
Apologies. No, I'm sorry. I'm reacting to what Your Honour is saying, so I'm taking myself completely out of my course. But I mean, I'm always grateful that Your Honour rarely leaves litigants into doubt as to where your mind is going. But
Well, let me direct your attention to what I want you to address me. I've read the onshore Dubai court's decisions of the 17th of January. I've read the agreement between the defendants of the 17th of January.
Yeah.
I've read the Dubai court order of the 5th of September of this year, and you've told me there have been some developments since. I'm not conscious that I'm aware of developments since, and I need to know what impact you say they have and what they are.
Well, Your Honour, can I, because I'm happy to address Your Honour on what those developments have been now, but may I just indicate briefly the course that I was going to take, and why. I was going to begin by taking Your Honour through the procedural history for the purpose of demonstrating that I don't need an extension of time at all, which produces some orientation. What I was then going to do was to just deal in order with the 5 grounds in my skeleton, namely JJC's stay. Now, of why it stops there. Now, if Your Honour wants to hear about what has been going on onshore, then in context you may want to hear about that then. What I would prefer to do, with Your Honour's permission, not to sort of break the flow, is to move on from the JJC ground to the 5 grounds that I have begin with, which is abuse at paragraphs 33 to 54 of my skeleton, public policy, which just occupies 2 paragraphs, 55 and 56. And then I have dealt with the stay grounds, where I say that the specific RDC 12, the RDC 4 case management and inherent jurisdiction can all be taken together. The reason that I wanted to end with what's been going onshore is because I apprehend that my learned friend's point of departure, so far as JJC stay, will be to say, in the light of what is going on, there is no conflict.
Yeah.
And that therefore it seems sensible for you to have had that update towards the end of what I've had to say.
Well, the reason why I raise it at the outset is because on the face of it, as I understand the 5th of September judgment, it's where the second defendant claimed a stay of execution of the English judgment, a declaration that other courts' judgments in support of the English judgment were, quote, not relevant, and thirdly, sought an order preventing any challenge to her ownership of the shares in the DIFC, and the court refused the last of those, saying specifically that the DIFC court had exclusive jurisdiction to decide on commercial and property interests. Now, if that's the current position, where is the conflict? That's the question I'm asking. If there's development in the position, of course, that may be entirely different.
Well, but Your Honour, yes. I mean, I can take it in detail. This is where the witness statement of Mr. Al-Kayali and the exhibit comes into play. So, if Your Honour would like me to do it now, do you want me to just take you through that chronology? So, I mean, just to say where we think that leaves us is let me say where we'd say we're not and where we are. Where we're not is that in the light of the further proceedings since that judgment which Your Honour has read, we're not, in my respectful submission, in a position where there is no conflict because it's out of the onshore system, because there has been an appeal by the second defendant.
Yeah.
And I think Your Honour will know in broad terms that that moving from first instance to appeal onshore, it's effectively a complete rehearing. It's not it isn't limited to an appeal in that strict sense, which goes on at cassation.
Understood. But the current position, though, is that the onshore court has said that this court has jurisdiction. Have I misunderstood the position?
Well, what the onshore court said is that it doesn't have jurisdiction on the basis that it has understood that if all is at issue here is a DIFC company, that is where it is concluded. But what is explained in the affidavit and the exhibit of Mr. Atelier is that that has been appealed by the second defendant, and
Yes.
that so far as my client's counterclaim is concerned, is that there was no ruling on that that claim at all by the first instance judge. So just
which counterclaim is that, Mr. Taylor?
So
which counterclaim is that?
That's a counterclaim by the first defendant, my client, Your Honour, which just take you to where it is. I mean, if I may, to take it chronologically, can I just give you some bundle references for your note as to just what has been going on in the onshore chronology?
Well, why don't you take me to the documents?
Indeed, I will. So, Ron, if you begin at 1525 of the bundle.
So which section is that in the case
So
line?
1525 case
Well,
line.
it's section F. Section F, tab 54.
Yeah.
I'm just getting there myself. I'm on a PDF doing the number search. But just while that's loading, just at a headline level, there are
Yes.
three elements to the onshore proceedings. One is the second defendant's appeal from the court first instance decision declining jurisdiction. Secondly is the first defendant's objections back to the CFI about its decision, because it hasn't dealt with the counterclaim. And then thirdly, of course, the Joint Judicial Committee proceedings are still live. So those are the three aspects. So what one sees, picking it up at (1524), in fact, paragraph 11, claimant contested jurisdiction on various grounds. And then there's the decision that Your Honour has said he's read of the 5th of September, dismissing it on the grounds of jurisdiction. On the 15th of September, my client's onshore lawyers filed an objection again directly to the Court of First Instance, saying it's deficient and to have it reviewed.
What were the claims and counterclaims? I'm asking Mr. Taylor.
So the counterclaims, Your Honour, were my client's counterclaim was for negative declarations and damages. Let me just find it in the...
That's paragraph 10, is it? First defendant asserts he be absolved from all his obligations. Wants declaration that he has no further or pending obligations towards the second defendant.
Yes.
Is that right?
That's right, Your Honour. I can show you where the appeal document is at 1557. And what I'm just looking for, Your Honour, is if I may just get a page reference from my Mr. Chu. May I just mute myself for 1 second, Your Honour? Apologies. It may go quicker if Mr. Chu deals with this bit. He's worked it out. 1 second. So yeah, it is, the detail is described. Sorry, I was having even problems that my WhatsApp was not working, at paragraphs 10 to 14 on 1524, which is what Your Honour has just read. What I was looking for was the reference to the counterclaim itself, or the translation of it. But as Your Honour has said, the substance of the dispute claim in the counterclaim is described in paragraph 10. And what he's done is described in paragraph 13. And that's actually fixed for hearing on Monday. So I think in sum and substance, whilst as matters stand, the second defendant's claims, including for negative declarations, are being kicked out, and those are being appealed to the Court of Appeal by the second defendant, is that where it stands is that on Monday, what will be addressed on behalf of my client is whether his counterclaims as described in 10 should be kicked out or not.
Yeah.
So Your Honour, what I say about that is that so far as concerns the JJC stay, I don't think it's relevant to any of the other, well, it's some relevance perhaps to the other grounds that I rely on. But what we say as far as the JJC stay is concerned is that the scope of the conflict is only conflicting judgments so far as concerns the dividend freeze element of the freezing order. But the remainder of what is going on and continuing to go on in the onshore courts, where you don't have to get permission to appeal, it's a rehearing. And in respect to my client's conflicting counterclaims, both drive at the conclusion that the shares belong to the ex-wife and the children, and that's being proceeded in both directions, is that is continuing conflicting proceedings that is the other vice which is set out by Justice Martin in 5 in the passages that I have summarised or drawn from paragraph 18 of the skeleton, where I've quoted 43, 44, 49, 57, 58, and 71 of its judgment, where he's clearly said that, you know, the other vice, apart from conflicting judgments, is parallel proceedings containing the same subject matter. Got to take a common sense and purposive approach to it. And I have quoted from how both my learned friend, Mr. Montague Smith, and Mr. Stoddard of Morton Ray's Fulbright very succinctly say that this dispute is all about who owns these shares. So that's what the conflict is. And then, of course, let's not forget the role of the Joint Judicial Committee. Because in my respectful submission, Your Honour, is that what has been confirmed by the Union Supreme Court in the Maidan case, which I have set out the key findings of in my skeleton argument, is that the role of having exclusive jurisdiction as tiebreaker as between the Dubai courts and the DIFC courts now sits with the Joint Judicial Committee, and it is in substance the same role which, when performed by the Union Supreme Court itself under the equivalent provisions of the Union Supreme Court law, it's with respect to that the Chief Justice Michael Huang said that in connection with getting rid of FNC is that the DIFC courts can't go anywhere near that. So my respectful submission, so far as the JJC state ground is concerned, is that regardless of what's happened at first instance, there are still pending proceedings which concern exactly the same subject matter. Who do these shares belong to? And now that the timing element of not staying under the new Lacan practice until the Rule 12 application has been dealt with, the moment you've dealt with that, the timing aspect will be gone. And unless Your Honour concludes that no, even though it's the same people and it's about who owns the same shares, this doesn't count as two conflicting sets of proceedings between the side. Sorry, I'm getting feedback now. Same parties of the same subject matter. You have no discretion but to stay at that point, and that was accepted in the Khan at 41. It records that it was accepted. They remitted it for a Rule 12 hearing at first instance, and it was accepted that if the DIFC court found it did have jurisdiction, that it would then have to stay. And so that's where we are as far as the JJC stay ground is concerned, where unfortunately, well, perhaps I shouldn't say unfortunately, the position is that Your Honour would not have a discretion, whereas what I urge more strongly is that under the remaining grounds is that you do exercise the discretion which you have, which I say is a very flexible one, which Athena and the Holy See, my respectful submission, has rescued from the what my learned friend called the test of rare and compelling circumstances, which I say is wholly misplaced. So what I'd much rather do is that this court in the typical common law way. When I say the typical common law way, which is that it lets the parties do the work, is that it stays with liberty to apply, so that if the claimant wishes to intervene and seek to set aside on the basis it was obtained by deceit the onshore judgment, then they can do that. That would completely obviate the need for further JJC involvement, and it would mean that this wouldn't return here, or rather return to the JJC, because two conflicting final judgments have been produced, which is the inevitable, in my respectful submission, an inevitable collision course of my learned friend prevailing in the relief which he seeks in his particulars of claim. So what is striking from the Maidan case in the Union Supreme Court is that they do point out, I mean, that where you've got a purely internal situation, which is what's going on between different courts in the Emirates of Dubai, that is entirely a matter for Dubai law, subject only, in my respectful submission, to the obligation to legislate compatibly, which isn't particularly engaged here. So you've got to stay anyway, in my respectful submission. Put it to good effect. As I said, perhaps teasing my learned friend somewhat, is that you will have seen that in Athena and the Holy See, which I can take you on it too, that they reviewed all of the case management of the stay authorities, which were in England, that largely arose within the context of the Brussels/Lugano setup. So in circumstances where there wouldn't be a foreign defendant there, without either permission having been granted outside the EU Lugano regime, or where Brussels/Lugano performed exactly the function which the banned civil, well, I say it's not banned, it doesn't apply in the DIFC courts, never did, the Civil Procedures Code, but you know, that's got all of the concepts of first seized. It enables one Dubai court to require another Dubai court to deal with the case. Now, my with the CPC not applicable in the DIFC courts, and with no attempt having been made to amend the RDC so that they dock with the CPC, so that they cohere, is that what you do is you get the party to do the right thing with permission to come back to you if they need help. There's all sorts of things that I don't want to put ideas into my learned friend's head, because it doesn't need me to do that. But there are ways in which the DIFC courts could assist the onshore courts if application was made with respect to evidence discovery, whatever. But there's a world of difference between assisting a sister court, and in my respectful submission, where the case is, and I can't see that he's putting it in any other way. I can see how he tried to get round it, saying, well, you know, it's an in personam judgment and we won't party of this. But they're saying in terms that your sister court was deceived into giving this judgment. Now, I accept that the authority that I rely on, the Kuwait Airways and Iraq Airways, was in the context of the English High Court system and how do you set aside a judgment for fraud by a fresh action in the court which issued it? But the point of principle here is that if it is said that a judgment which has already been enforced in the DIFC is to be impugned because the court that issued it was deceived, then surely the court to address that proposition to is the court that was deceived. Does the DIFC court, is it right that the DIFC court should make up its mind whether the Dubai court was tricked into entering this judgment? And I do say it takes effect as a judgment. It's not. I've drawn lightly comparisons to the family division procedures in England, but a decree nisi cannot be made absolute unless the arrangements for minors have been blessed and sanctioned by the court. And of the 8,000 financial assistance cases in 2019, 80% of them had settled by the FDR, which has now been renamed with another acronym. It's called the MIAM, I think, because they changed all the rules in the family division. But it is mandatory conciliation procedure that you've got to get a special exemption to get out of, and 80+% of maintenance orders, etc., have been arrived at by consent. But the stewardship function of the court is a very serious one, and this was matrimonial property. So, Your Honour, I have and I thought I was doing incredibly well for time until I realised that my watch has stopped. So I don't know where I am doing in time, because, Your Honour, I have responded to your invitations to what you wanted to hear, and I've not even looked at my speaking notes. Can I
take your time and tell me what you want to address me on, and take it in whatever order you like.
Yeah, I just wanted to get a time check as to where I am, because how long I've been going for.
About an hour, I think.
And Your Honour, when did you propose to break, and what is the time allocation for each side? So just.
I don't think we decided any of that. You're in Dubai. Where are you, Mr. Montague Smith?
I'm in London.
Right. Well, I should think the simplest thing is for you simply to continue until you finish, Mr. Taylor.
Sure, happy to do that, Your Honour. But I mean, what I was just trying to work out is that as to get an idea of when you did propose to take a break and how long, because I know that Your Honour, I'm sure would sit late, but the registry presumably will want to be gone by 5. We're at 1:34 here, so we've got plenty of time. So when was Your Honour proposing to take a break?
Well, I suggest you go for another half hour, and then we'll take a short break at that point. It really is. It's it doesn't fit with anybody's meal time, so to speak.
No, fair enough.
So why don't you go for half an hour, and let's see where how much further you've got to go at that point.
Fine. Thank you, Ron. Well, what I think I could usefully do there is just to take you through the somewhat tortured procedural history. Mr. Mannis attempted to set that out at paragraph 10 of the preliminary outline submissions, which are the Divider 5, page 50. But let me just give you, if I may, Your Honour, a quick chronology, because the way it was organised there was that paragraphs 10A to C, we dealt with the 021 part 8, D to H on the part 7,
Yeah.
L to N on the consolidated claims. But what is more helpful, I think, to do is to have just a straight chronological run across the two, so you can see what emerges. And the starting point, so and this goes to the question of, is the Rule 12 application timely and is an extension of time needed? And I say it's not. So the first milestone, which, and I think just take a note of these bundle references for your honour's note, is 19 at 258. We see D1 acknowledged service in the Part 8 claim, ticking yes to contest jurisdiction. And what one sees on the 22nd of April, importantly, is the first defendant's application numbered 4, which is 336, and probably is worth taking a quick look at, because you'll see that that is explicitly Rule 12. My system's gone off again.
Do you mean 337, Tim?
Beg your pardon,
Sorry.
337, I think.
Bundle T, tab 34. This is the application that's been dismissed just now.
Well, I want to come to that as to where it's been dismissed.
Just now it was dismissed by His Lordship.
Oh, I beg your pardon. Yeah, that is the one that. Well, so, Your Honour, there may be a question as to whether the challenge to jurisdiction that is required needs to have all of the. Sorry, I'm getting feedback from someone again. Needs to have all of the grounds in it, and Your Honour has just dismissed it now. It's never been dismissed before, is what you'll see. So that was explicitly under Rule 12. And I want to take this to make progress so we get on to the half hour. The next step in the chronology is the 9th of May at Divider 27, page 307, which is the first defendant's acknowledgement is filed in the Part 7 claim, ticking yes to contest jurisdiction.
307.
307, only, yes.
I think I have it at 308.
Oh.
Right. Well, it looks like as the bundling went away. Let me actually get to it in the bundle, because it looks like all of my page references are one out.
Yeah.
The next milestone is on the 9th of May, the claimants file their particulars of claim. I've got it 304. So
yeah,
the next is that it immediately files its application number 1, which is the immediate application, immediate judgment application, which is at tab 1 divider 9. It's right at the beginning. And also on the 23rd of May, the first defendant files application 3 on the 23rd of May, that is, which is a divider 692580. Now, Your Honour, what's just worth noting there, because that we all know about making one's submissions logical and if not chronological and if not alphabetical, but here they've got to be numerical, because what becomes rather confusing is that application number 3 by the first defendant becomes what is referred to as application 4 as allowed by Her Excellency Maha Al Mary on the 29th of June, which is a divider 3314. And then, having been allowed that application which is stayed, sorry, that application for a stay allowed by Her Excellency Maha Al Mary is then dismissed by His Excellency Ali Al Madani on the 1st of August, which is at divider 31316. At that stage, it's without reasons. The next milestone is not in the appeal bundle. I don't think it much matters, and that is on the 23rd of May. The first defendant issued a stay application, which is numbered 6. It doesn't explicitly invoke RDC 12, but it challenges jurisdiction on the basis that it's for the Joint Judicial Committee to determine it. That application number 6, which is in the part 8.021, becomes application 2 as described and allowed by Justice Maha Al Mary on the 29th of June.
What's the reference to that one?
Sorry, that was, it's not in the hearing bundle because it wasn't referred to in the preliminary outline submissions as one that was being advanced. That was application number 6.
Yeah, but where is it?
Sorry, it's not in the bundle.
Oh. Well, I've never seen it then.
It's been determined.
It's been determined. Yeah.
I hesitate to interrupt. I know my learner friend wasn't involved at this stage of proceedings.
I just need a bit of clarity as to what exactly that application was.
Can I provide that? And my learner friend wasn't involved, and so I mean I understand his position. But perhaps if I just explained what we understand the applications were, and then you can take my learned friend can take it from there. There were in fact 4 applications, 2 by each defendant, 1 in the Part 7 claim each, and 1 each in the Part 8 claim, and all of them sought stays pursuant to the JJC decree.
So are they all in identical terms to the one I'm looking at page 2580?
I can't warrant that, but they would have said substantively the same things, yes. And they were allowed on paper by Justice Maha. I'll come on to why that was. And then they were set aside after a hearing by Justice Ali, and that's his judgment of the 1st of December. And he dismissed all of those applications at the same time. I apologise for interrupting. I hope that helps to clarify.
Not at all. It's made it simpler. But
are you content, Mr. Taylor, that I should treat all 4 as being on essentially identical terms to that which appears at page 2580?
In substance, Your Honour, yes, unless I'm corrected in relation to 6, because I'm at a similar disadvantage. I think the reason, and 6, in terms of what is said in the preliminary outline submissions, that they're to be in support of all that that was in support of paragraph 1.2, it was in support of applications numbered 3, 4 and 9. So look, the point that, put very shortly, there have been 4 applications seeking to stay on the basis of JJC jurisdiction, 2 by each defendant, which were all initially
Part
allowed.
7 and Part 8.
Yeah, all initially allowed in June and all dismissed in July. The only one that had been left behind is the one that Your Honour has just dismissed this morning, which was explicitly Rule 12. Matter of timeline, Your Honour, unless the position is taken that there's a statutory submission if you don't apply for a stay explicitly referencing the case management powers under Rule 12 within 14 days after acknowledgement service stating an intention to contest, then certainly those applications were timely made. I mean, to begin with, the one that Your Honour has just dismissed was timely made, and that it was after, and well within 14 days after the acknowledgement of service in the Part 8. And then the JJC stay in the Part 7, which we've just been talked about, was timely made and had not been dismissed before the 2 actions were consolidated on the 22nd of June by Justice Maha, which is an easier way to refer to her, which is at 29.3.12. And that consolidated and ordered case 030, i.e. the Part 7, to be the active case going forward. So at that point, the Rule 12 application, timely issued in the Part 8 claim, was extant in both Part 8 and Part 7 claims. And then on the 29th of June, the stay was ordered on the 4 JJC stay applications just described, but no mention of the Rule 12 application, which Your Honour has just now dismissed on that basis. So the next milestone is that on the 1st of August, we get, without reasons, Justice Ali Al-Madani's dismissal of the 4 stay applications which Justice Maha had acceded to. In between that dismissal and the reasons arriving was when my client, then in person, with a certain amount of disclosed ventriloquy going on while we were waiting for a Part 1 representative, filed application number 9, which is the only application which has formally been listed before Your Honour today, apart from the immediate judgment application number 1. So my primary submission, Your Honour, is that no extension of time request order is needed at all, because where you have got both an explicit Rule 12 application, I mean, my learned friend will want to say perhaps that it is restricted to the specific grounds that Your Honour has just dismissed. That was issued well in time in the Part 8 one. And to try to say, following consolidation, that because Rule 12.4 states that the Rule 12.1 application must be made within 14 days after filing an acknowledgement, that somehow if you file it prematurely because you challenge jurisdiction before you've even acknowledged taking to contest, that is, prematurity is out of time. And I say that can't be serious. It reminded me, your Lord will be familiar with the Buchanan and Rucker, where Lord Ellenborough complained, can the island of Tobago pass a law to bind the rights of the whole world? Because you could nail a writ to the courtroom door when someone was absent from the island. Well, plainly, couldn't use that to sue someone who was absent because they've never been present in the first place. And to say that we need an extension of time when everything that the defendants have been doing is been making as clear as could be that they're challenging jurisdiction, would, in my respectful submission, be the return to the old days of the debate as to whether, if you filed a conditional appearance and challenged jurisdiction, you were having your cake and eating it, which was Harris and Taylor, or not, which was Reed Dulles Will Trust. And your Honour will recall Henry and Giaprosco said, cake wins, and the dicey view that it was repugnant to common sense that someone who was challenging jurisdiction should be submitted, had to be sorted out statutorily in the Civil Jurisdiction Judgments Act to say that no step either to defend assets or to challenge jurisdiction abroad will give rise to a deemed submission. So I would say, A, that having regard to that timeline, is not late challenging jurisdiction, and that challenging jurisdiction prematurely must surely be within 14 days after the acknowledgement, just as Alice could have more jam without having had any in the first place. And that even if that's not right, it would be
tea, not jam.
Tea, I beg your pardon, it was tea. The jam was, of course, always tomorrow.
Yes.
Yeah, Your Honour is absolutely right to correct me. It's evidently not just my biblical quotations that have been taken out of context. So, is that what? Now, again, Your Honour, if that's the reason I wanted to go through that now is that if Your Honour is with me that no extension of time arises, then it becomes unnecessary to deal with the question of whether relief against sanctions is necessary, because if I do have to deal with that, what I would take Your Honour to is the Denton case and the distinction which it appears that Justice Ali Al-Madani has held to be without a difference between the form of the relief against sanctions formula in the CPR pre-Jackson and post-Jackson, because the RDC has still got the pre-Jackson formulation. And what I would need to show Your Lordship was that actually there was a Jackson reform driven policy change in England that that Denton adjusted, having regarded as having gone too far in a previous case, whereby the new message is that you can't have any slack litigants. Time limits have got to be taken seriously, and relief against sanctions became much more onerous. Now, point one, in my respectful submission, if you look at the timeline, no extensions needed anyway. And to say that the formal challenge to jurisdiction must explicitly reference Rule 12 would be a totally unacceptable gotcha. And that even if that is wrong, and it was technically out of time, is that it would be grossly unfair for there to be, well, not only unfair, but pretty pointless, given what I say are the overwhelmingly sensible case management considerations that say that you shouldn't leave it to the JJC to put this in the right court, because functionally you can do it yourself at much less time expense to the litigants and to the, I was going to say to the UAE taxpayer, but that's probably not, but to the Emirate of Dubai, which funds all three courts, i.e. DIFC courts, personal status, and the JJC. So, Your Honour, I'd say it is 3 minutes to, and what I was going to then go on to knock through, I hope, pretty quickly thereafter, having dealt with the convoluted procedural timeline and extension of time, is that to just go through the 5 grounds one by one.
Yes. And how long broadly do you expect that to take?
I wouldn't have thought that it would take more than, I would hope, 45 minutes. Subject, and I'm happy to crack on now if I can just top up my water, if that's what Your Honour would prefer. Whether we need to come...
Why don't we just take 10 minutes out now?
Super.
Take 10 minutes out now, and people have a cup of coffee or whatever, and give everybody a short break, and then we'll continue. So it's we'll start at 10 past the hour.
Thank you, Your Honour.
Very good. Thank you, my lord.
Thank you. Yes, Mr. Sarah.
Thank you, my lord. I've noticed that my learned friend is addressing you as my lord out of habit. I think it'd be helpful if we both addressed you in the same way.
It's Sir John Chadwick used to insist on being called my lord because that's what he said he was. I am not troubled one way or the other. I think technically it ought to be Your Honour, but I'm not bothered at all. You could do what you like.
Thank you, my lord. It rolls off the tongue a bit easier. What I was going, or am going to do now, is just take one by one what now become the 3 remaining grounds, because, as I said, of the 5, we've dealt with JJC stay and the Rule 12 and ordinary case management stay grounds fall to be treated as one. So what one comes to then first, my lord, is notes according to a model. Just give me 1 second. What I've called the abuse ground, which in the skeleton argument does Your Honour have the, so now I'm calling Your Honour again, my Lord, do you have the skeleton argument to hand as well?
Yes.
It starts as at paragraph 33, where I've said that one's bound to accept that there is jurisdiction as to the money judgment, but that it would be not right to shut one's eyes to what is the purpose of the judgment, which I say is a collateral attack. And my Lord, I pick up at 34 in the skeleton that there's been a recent case, which I don't think I need to take the Lordship to, Municipo de Mariana against BHP at 2022 EWCA Civ 951, which has essentially reconfirmed.
Yeah.
Hunter remains the Blocus Classicus. Categories of abuse of process are varied, not closed. Courts have declined to define or circumscribe them. Some well-established categories, of which collateral attacks are one, and within the elastic category of abuse of process is that Lord Justice Diplock had also said that collateral attacks can come in many forms. Now, my Lord, what I've said that is, I think, most closely on point in this jurisdiction is Your Lordship's own decision in GFH Capital and Hague, which is, I can take Your Lordship to it in the authorities bundle, but does Your Lordship remember that case?
Yes. Not in any great detail, but.
Well, I mean, and I in my respectful submission, it's not necessary to recall it in great detail, because the gravamen of that decision was that in circumstances where Mr. Hague was essentially saying that he was only in prison because some of the substance, what he appeared to be saying is that if people had done various things, he wouldn't be in prison. And one part of Your Lordship's judgment was, look, inaction can't ground a cause of action anyway. But what is material here is that for you to have entertained a claim for false imprisonment, malicious prosecution, that sort of a claim would, particularly the false imprisonment claim, would cut directly across the Dubai criminal courts having granted him bail on particular terms. And that was what you said, Your Lordship said, gave the claim in the DIFC courts the necessary quality of making it an improper and therefore abusive collateral attack on the judgment of Dubai courts. My Lord, I say that that is on all fours with the present situation, because if let's assume against my client and D, and the second defendant, his ex-wife, that it is absolutely correct that the motive of Mr. Manners and Catherine Ziller was to say, look, here we are being pursued by MAD and the Doggers group, who are coming after me for everything I've got. Why don't we get divorced and get the family court to make a judgment whereby it orders that the shares, which were then sitting in the JAVSA entity 5 Aces, must be transferred and registered to Catherine Ziller in her own name, and Enzo and Santino, the 2 children. Now, in my respectful submission, that it's inescapable, almost inescapable, to say that they were misleading the court, deceiving the court as to the propriety of the court, carving up the matrimonial estate in that way. And I mean, Your Honour, this does, there are cases where, for example, you get proceeds of crime and confiscation orders running up against family court decisions, where, you know, the family court looks at what the family assets are and how they're going to be divided in terms of capital claims and clean break, etc. But what one has got to look at, and I think one does have to sort of go through take at least a cursory scan of what will be pretty unfamiliar provisions, namely the personal status law, which is Law 8 of 2005.
How's that going to help me, Mr. Taylor?
Well, I mean, and it's that what my learned friend appears to be submitting is that he is saying, number one, wasn't a judgment at all. It's just an agreement. I think he sort of, although he doesn't put it in these terms, is that it appears to me that the gravamen of his submission is that it's somewhat like a confidential schedule to a Tomlin order. But what I say that one can get from the law is that it is said that any judgment of the court of the family court, I've called it in shorthand, that disposes of property is self-executing. It has been executed, so it has been, and I don't think that this is in contention.
The transfer shares, it's on that basis.
Well, by means of the
execution and
execution by court, and I don't know is that
yeah.
Is
what I'm interested in. I mean, I don't have any doubts about the jurisdiction of the onshore Dubai court in relation to matrimonial assets and its exclusive jurisdiction at that. But is there room, as there is in most jurisdictions, for parties to go back to the matrimonial court on a change of circumstances.
Well,
you don't know
I mean, look, is that what I could take your lordship to, but I mean, on the basis that I think it's important to realise that to know what you don't know is that there's plenty of there are multiple provisions in what is now the Civil Procedures Code, as subject to my constitutional point, amended by Ministerial Regulation 57 of 2018, which provide for joinder of interested parties, etc. And they do so in terms that are, sort of characteristically civilian and inquisitorial, that inevitably and this, it's replete with such such provisions, and I can show you some examples of it. But bearing in mind that this is a common law court and adversarial in nature, bearing in mind that the Civil Procedures Code has no application in this court. I mean, the fact that I say that the rationale which has led to that conclusion is flawed doesn't make the outcome any different. It's not applicable here. Is that whereas if it was between two onshore courts, there's a provision for me to apply to you to say, look, transfer it to the other court, and the other court's got to deal with it. Is that here, in my respectful submission, is that what one does is that the claimant is coming to this court, has obtained and seeks to maintain freezing orders, as to which I have omitted to say at some point, I think Your Honour should hear from Mr. Montague Smith about whether the undertakings to enforce those freezing orders only with the permission of the court here or in London have been complied with, because I don't know the answer to it. There's no indication.
Can I just intervene on that front?
Yeah.
Because my own friend's making an implicit allegation of contempt of court. If he's going to make that allegation, he needs to give particulars. It's not appropriate for him to. He's done it in paper. He's now done it orally. To imply and insinuate that my clients have breached orders. They haven't. If a proper application is put or a proper allegation is put, I will try to deal with it. But it shouldn't be dealt with in this way, my lord.
Well, my lord, I wasn't proposing to deal with it now, but I mentioned it because I've forgotten it at the outset. But I don't accept what my learned friend says, that even though I've said some explanation may be required, is that what I can show your lordship, and I don't think now's the time to do it, but I think I would want to do it when addressing the freezing order, is that so far as I can, is that it is clear that both the English freezing order had the usual undertaking not to seek to enforce the worldwide elements of that order or seek similar relief in any other jurisdiction without the permission of the court. And I have seen no indication that that permission was obtained before going, in the first place, even going to Dubai to get the DIFC freezer, which is in substantially identical terms, except that I think the standard undertaking, which was from one of the early Derby and Weldon cases, doesn't include the language about all similar relief. It's about enforcing freezing order. So far as what I would have anticipated, and look, two extremely experienced firms on the other side, so I didn't want to go off the deep end accusing them of things, and I'm not. All I'm saying is that I have seen nothing that suggests that permission was sought either in London before getting the freezing order here, or here before getting attachments in July in both Monaco and Belgium. Now, ordinarily, what one would expect to have happened is that I quite understand that you would not have gone in London inter partes for permission to go, forgive me for using the Latin, but it's easier to understand. You wouldn't have gone inter partes in London to get permission to go ex parte in Dubai. What you would do is you'd go ex parte in London to get permission saying we're going ex parte in Dubai. And once you've gone ex parte in Dubai, ordinarily, you would amend the order in London to say you will not enforce it outside, save as to permission which has been given in Dubai. Now, I don't know the answer to this. Mr. Montague-Smith is shaking his head, and I don't want to put it too high, but on the face of it, I can't see, and I'm a Johnny-come-lately to this litigation. I have seen no indication that they have sought the necessary permission, and he's quite right. It is, if that is so, it is a breach of an undertaking, and I have the authorities on it. But I can't prove the negative that he has not been to get permission. I can just say that to my best of my instructions and understanding, there are no indicia whatsoever that permission has ever been sought. So I'm sorry, I've been taken off on another diversion. But where I was going to deal with that, will deal with that, is at the end regarding what is to be done with respect to the freezing order. Your Honour froze for a moment there. Are we still?
I've heard you all.
You're still with me. Okay. So what I was seeking to make good, Your Honour, is that, my Lord, is that in sum and substance, it is a learned friend's case that the divorce judgment or divorce agreement, as he prefers to get it, was obtained by fraud. So let me just show Your Honour two things. First, let's just look at some of the provisions of the personal status law, which I can refer to and take you into the bundle in the context of what was ordered in the judgment, to say why I say that it is to be regarded as a judgment, and you can't miss out the vital step between their allegation of the first defendant having put the beneficial ownership of the restaurant out of his hands and into his wife's back in 2020, and the events of January 2021 when this is ordered. So the first thing in relation to the judgment, if one looks at page 2711 of the bundle, and if learned friends in case file, may be able to give you a divider number for that.
That's right, I've got it. I printed it off a long time ago.
Right. Is that it's paragraph 5 of that.
Yeah.
The first party, which is the second defendant, shall allocate the revenues or profits of the two companies or corporations, and one is the Belgian company, which we're not concerned about here. What we're concerned about is the dividends of the DIFC company, to cover the expenses of the children in custody only, including housing, education, medical care, clothing, specifications, servants' wages, lucky children, travel allowance, or any circumstances that may arise in the future. The first party shall not be entitled to use the revenues of these two companies or any companies affiliated therewith for her own benefit, or to use these companies for her own business in any way. So that's what it says, and I can see that my learned friend's case is that that was done deliberately to shelter the assets and the children. If one then looks, for example, if one turns up the personal status law, which is a divider 126 at 3679, and just take a look. So if you go in it to about 3710, is where you. Sorry, I'll just get my copy of it, not in the bundle. So I can invite your lordship to look at, say, articles 55, 63, 64, and especially 65.
Hold on, give me those again. 53.
55.
Yeah.
63.
Yeah.
64. 67. And especially 65. Is that what all this is about? Is wife's entitlement to maintenance, etc., to divorce because she has not been properly maintained, etc. And I would remind Your Honour that the divorce proceedings, even though there's some mention in the evidence of the first defendant having said that it began in September, is that the divorce petition is recorded as having been on the 21st of November. I don't think that that's disputed, and nor is it disputed that as at the 21st of November 2021, this was after the trial in front of some of Mr. Justice Burton had concluded, but before he had rendered his judgment in the December. So, as one will have seen from, if my lord had the chance to see the passages which I extracted in the in seeking alternative dispute resolution, is that the case was, in terms of liability, like Waterloo, a damn close run thing. Is that there were two equally extraordinary stories. So at this point, even though I say, even if you assume against my client and his ex-wife that it was all a put-up job, is that I think it would be very dangerous to assume that the grounds that she alleges of desertion and etc., that she, that the marriage wasn't, is it a fake divorce of a real marriage or a real divorce of a fake marriage?
Well, I can't assume anything, can I?
You can't assume anything, indeed. Right. So, I mean, obviously, prejudice has been ladled on with the trial very artfully, and it's, as I said, easy sport when you've got Mr. Justice Burton having found my client to be a liar. But you've seen what a difficult exercise that was. It was completely binary. There was no room to conclude that one or the other was lying. And there's no other middle ground, right? Unlike the outcome on liability, where a 60 million claim produced an 11 million judgment or thereabouts. So, and he said a plague on both your houses to the experts. That's a great shorthand. So, what I'd then ask you to look at in that personal status law is Article 107, which is at 3718. alimony to be ordered and is deemed a self-executing judgment. No. Perhaps without the assistance of expert evidence, one should be careful about reading too much into that.
Which this is a different piece of legislation, is it?
Sorry, am I perhaps?
Article 107.
This should be of the personal status law. Yeah.
Oh yes, yes, yeah, yeah. Federal law and personal status. Yeah.
But I mean what we do know is that it was certainly executed as a judgment under the judicial authority law.
The waiting period is the 1 year Islamic period, is it? During which there's the possibility for retraction.
Your Honour, I believe that is right. I mean,
that's my
it's quite a it's a fascinating read, having been produced in 2005. Has some.
Well, it's only a matter of curiosity as to what's meant by her waiting period.
Well, the waiting period. No, I follow that, but I think that what we can more safely say is that we know that it has been executed in the DFC. And is my lord familiar with the VIH case? It's not, sorry, perhaps it's XXX and YYY, in which Justice Sir Richard Field drew a distinction between the mere execution of judgments within the DIFC. I can take you to it, where there needed to be something executable.
Yes.
Right. Because there had been a judgment of a previous judgment of the Chief Justice, I think, sitting at first instance, where he had sort of said that there's no choice under the judicial authority law, under the Article 7 of the execution judge can't look behind a judgment that is executable in Dubai, in the DIFC at all, and he put the what never, well, hardly ever. Whereas what Sir Richard Field did in the that XXX case was that there had been a Dubai Court of Cassation judgment holding that a DIFC seated LCIA or DIFC LCIA, I forget which, Mr. Montague Smith was on the other side, arbitration clause was invalid. And Sir Richard declined to recognise that judgment because, as far as he was concerned, it had been an arbitration agreement subject to English law. I think they concluded that the proper law was, whether it had been English law or DIFC law, made no, never mind. So what we do know is that whatever it's called by Mr. Montague Smith as to what is onshore an agreement, is that it has been treated and executed as a judgment in the DIFC. It's certainly become a judgment in rem here, because the register, there's clearly exclusive jurisdiction. The register stands as prima facie evidence, etc. And so I say that where they're saying that this has been obtained by deceit, is that you have to ask yourself the question, who has been deceived? And that is not the execution judge or the registrar in the DIFC. It looked like a judgment, it smelt like a judgment, felt like a judgment. So good job they didn't step in it, they executed it. If the claimants, or indeed any other creditor, may be standing, but if the case is that it's been obtained by fraud, then they should go back to the court they're saying is defrauded. Now, and I'll just take you to what Mr. Montague Smith my learned friend was saying at the ex parte stage. But before we go there, if we can just look at Decree 57, which is the reform of Civil Procedures Code, which is divider 89. It starts at page 2837. But if you scroll to 2917, you get to Articles 184 and 185. There's quite a large number of sections of the whole of chapter 11 of starting at 183 of part 5 of the law, section 5, which is attached, is about how you enforce money judgments, etc. And chapter 11, starting at article 183, is imprisonment of the debtor.
Yeah.
And if you particularly get down to 185, which is largely about when you don't get sent to prison, is that if you see you can't under 1851C be sent away if you're a spouse or an ascendant of a creditor, and the less the debt is a prescribed alimony.
Yeah.
So in terms of a conflict, and I put references to the relevant paragraph of the freezing order in my skeleton, is that the freezing order that is directed at the second defendant prevents her from using the dividends in the way that she's obligated to use them. And at the same time, the way that takes care of my client's maintenance and alimony obligations towards his ex-wife and his children. So
I'm not sure I'm quite understanding that, Mr. Taylor.
Sorry, so what I'm saying is that the effect of the divorce judgment, and paragraph 5 that I just took you to, was that
yes, I understand it stops her from using the dividends.
But yes, but that was in discharge of his obligations to pay. So look, they've obviously got a shared interest to the extent that the recipients of this, beneficiaries of it, are the kids. So, just because people get divorced, as many do, doesn't mean to say that they don't have maintain the same interest in their children being properly cared for.
Yeah, no, I understand all of that.
And he's under an obligation to pay, and this is how that obligation is being discharged. And the dividend freeze prevents the monies being used for that under the freezing order.
Well, I don't see how that impacts on him with the possibility of him going to prison. But well, there it is. This is an arrangement that the court sanctions. It works on the basis that the second defendant, the wife, owns Five Dining Corporation Limited, and is going to transfer 33% interest to each of the two children,
Correct.
and that she is going to allocate the dividends to the expenses of the children. The first defendant is handing over a company called MA Development to her, right?
Yes.
And the whole, and there's some other odds and ends, but
Yeah.
the whole deal is you know, that's intended to sort the position out, broadly speaking.
Indeed, my lord, and I mean, I do understand that it may be the case that having made these arrangements has discharged his obligation, and that in terms of standing, I mean, and my lord, this application 9, which has been listed before you, was made seeking directions for there to be a 2-hour CMC, because it was crafted, that application, at a time when the reasons why applications had been dismissed by Justice Ali Al-Madani, the fact that they'd been dismissed was known, but the reasons weren't. And from the slightly convoluted procedural history, the question of what matters were determined or what was spent, etc., was pretty vexed. That's why I thought to say that the second defendant, it was anticipated that the second defendant would be here, because I appreciate, as a matter of standing, the freezing order is directed at, this freezing order is directed at her, and she is more naturally the person with standing to say, look, this is wrong, to have it set aside. That's why I'm saying that actually, if my lord, you were minded to snip away the dividend freeze based on what's before you now, then obviously that would be fine. But what I'm saying is that the question of the discharge of the freezing order or variation of it should go off to be determined at a later date, and that's what I wanted to have the directions hearing to organise. But all that has been listed is the immediate judgment application and the latest explicit Rule 12 application. So what I was just going to show you was that if you look at what my learned friend was saying, if you go to this was when he was applying ex parte to Justice Lord Angus Glennie at 2513 to 14. And I think at this point in time, my learned friend had not seen the divorce order, but understood it to be out there. I think that's right. No doubt he will correct me if that's wrong. And what he was saying was, you see where he says, let's just assume there is some sort of divorce order out there. The reality of that process, if it is truly a contested divorce process, it may well take months, probably years, in fact. What he's saying is that there was a contested divorce that was started in September, and by January they'd already got to an order. So he says, so the likelihood is, if there is an order, what has happened is that he and the wife are using that process as a cover for the transfer of assets. And he goes on to say it's probably only rubber stamped by the court. Well, I would agree. He says rubber stamp. Well, sorry, I beg your pardon. Is that it came on to be rubber stamped in the DIFC. But in my respectful submission, there has to be a deliberative process which is, a lot less superficial than getting, consent to a Tomlin order, when what is being blessed is arrangements for the care of minors, etc. You won't, your decree nisi, which they've now called something un-Latin, is not made absolute if provisions are not there for the minors in English matrimonial proceedings. So this is, even though plainly what went on in the DIFC was judicial, it was the ministerial end of the function, was no deceit. And this is what they were alleging. He went on similarly at 2537. He says, so what we're being told on 3rd March is that there had been a divorce since September. Well, that isn't correct. I mean, it may be correct that he was told it, but it certainly isn't correct there had been a divorce. But what had been going on, we don't know. Which he had not told anyone about. He had nevertheless been able to transfer the MA development shares back to himself on the 3rd of January. Then about 15 days later, has decided he's going to transfer it back to his wife, pursuant to divorce order, said to have been issued on 17th January, which does accord with what my lord has seen. It said that this divorce raises real serious issues between the parties, and that there's serious allegations being made, and that those are resolved in disputed proceedings within the course of what's 3 months. We say it's simply not credible. So, my lord, in a sense, I'm saying, so what? In other words, so what if everything he says is right? Doesn't make it not a judgment. The sister court with exclusive jurisdiction in the area doesn't make it right for the trust claims here, the proprietary claims here, to try and do an end run round a court saying that it had been deceived.
I'm sorry to interrupt. That's not all that I said about the effect of the court order. That's not actually what I said about what we would do with the court order. There were submissions later on. So if you're going to show my lord those submissions, you might want to take him also to page 2541, where the judge asks in terms at the foot of the page, what would you do about the Dubai court order if there was one? Answer, our starting point would be that this court can simply ignore it for 2 reasons, and then I develop those submissions.
That is certainly so, and if I may, if you're happy with that, that is what you repeated in your skeleton argument for the set aside, is it not? In other words, you made some complaints which I completely understand about how your submissions had been characterized, and at page 12 of your skeleton argument, which is in the bundle at I'm just looking for the bundle reference for your skeleton argument on the set aside, which is in there. It's at 70. It's at 2582. 2585.
I'm just reading what was said to the Lord Blenny.
Yeah.
Yeah, you're taking me to what, Mr. Taylor?
What I was going to, because I think this is where a learned friend at what is internal page 12 of his skeleton argument, which starts at
Paragraph?
page 2582, if you see paragraph 71.
Yeah. Yes.
He's complaining about selective quotations, and I certainly don't want to be accused of doing the same thing. And then what he goes on to, subparagraph 2, is this is where he's asked, what would you do about the Dubai court order if there was one? And he develops as to why.
Yeah.
He says it could be ignored because in substance he's saying, I think, two things. He's saying, one, it can only be a judgment in persona, because and therefore, since his clients had no notice of it, were not party to the proceedings, they're unaffected by it because it's only creates a res judicata between the immediate parties and their privies. He's now presumably saying, as I understood your lordship to understand, that the children are the privies of the mother in this litigation. And then the second thing that he said is that it couldn't be a judgment in rem because only the DIFC courts could make a judgment in rem with respect to the shares. Now, I have quoted from what Dicey, Morris and Collins has had to say about judgments in rem and how they're to be regarded. It's unfortunate because I'm a bit challenged not having access to Westlaw. I think that I was citing the paragraphs of the previous edition that have now been updated to the correct one in the bundle. But I say that this is a sleight of hand, that it's misconceived, because as far as I'm concerned, yeah, obviously what came to pass in the DIFC is a judgment in rem with respect to the shares. But what one has got to look at is how do you characterize the divorce judgment itself. Now, in terms of what I think you get from Dicey, is that in terms of what he's looking at is English conflict rules as to what will be regarded as a judgment in rem that's incoming. And I think even if you took that approach, certainly the divorce decree itself is a judgment in rem.
Well, that's a matter of status.
That's a matter of status, but in terms of the way that it's expressed in Dicey, he talks about judgments, and I don't think this has changed in its formulation.
Where is this in your skeleton? There is a paragraph.
Sorry, as where this is in my skeleton, which is probably the easiest place to pick it up. Just get rid of Mr. Montague Smith's skeleton.
I think it's paragraph 49, my lord.
Yeah.
So I don't think it's gone to another paragraph in the current edition. I don't think it has changed. A judgment in rem is a judgment where under either one, possession in a property or thing is adjudged to a person. The term is also used to describe an adjudication as the status as a decree of nullity or dissolution of a marriage. True, but irrelevant here because it's the transfer. He also notes that the English private international law rule against the recognition of judgments in rem concerning immovables that are not judgments from the court of the sitters are not recognised. But he points out that rule, which is the subparagraph of what was then Rule 47, I think it's become Rule 50, doesn't apply to the non-recognition of judgment in rem is confined to immovables, not movables. So I think it's a technical matter. The question is, what would is this to be regarded as a judgment in rem in Dubai?
Well, I'm just looking, and I'm looking at an even older version of Dicey than the one you cite, because that happens to be the one to hand where I am.
Right. Doesn't mention repugnance to common sense, though.
Rule 40,
yeah,
as it was in the 14th edition.
Right.
Which is talking about foreign countries, right? And
yeah.
I appreciate we're talking about Dubai here as opposed to DIFC, but a court of a foreign country has jurisdiction to give a judgment in when capable of enforcement or recognition if the subject matter of the proceedings wherein that judgment was given was immovable or movable property which was at the time of the proceeding situated in that country. That's the basic rule. I'm sure that hasn't changed in any edition of Dicey. And for these purposes, therefore, looking, and I appreciate the difference between looking at onshore Dubai and DIFC as compared with looking at quite a foreign country. But we're looking at what the nature is of a judgment in rem. And this essentially has to be taken as a judgment in persona and between two people on division of their assets, with, of course, the children's interest firmly in mind. But that's basically what it is, isn't it, Mr. Taylor?
Well, two answers to that. Number one is that I do think that is the right question to ask, is how is that judgment to be regarded as a matter of UAE law as applicable onshore? It isn't, strictly speaking, a conflict law question to recognise. And in fact, my learned friend's recent case in the Court of Appeal, I forget whether your lordship was on the panel, has sort of certainly cut down the idea that you default to English law. So I think that's the question. But I think the more important thing is that as a matter of the public policy ground, and public order ground, it somewhat misses the point. In other words, the key point is the Iraqi point of principle is the House of Lords Authority, the Iraqi Kuwait Airlines Authority, which, as explained in the fraud textbook, is a long-standing principle that if you're going to seek to impugn a judgment as having been obtained by fraud, you should do it in the court which issued it. Now, I appreciate that we're moving that principle to a different context, which is what is the proper dispensation and how should this court of limited jurisdiction regard this matter. I hesitate to use the word appropriate because, of course, the the F word has been banned from the DIFC. We can't talk about forum non-conveniens, but the test for case management stays, restated and corrected in Athena v. Holy See, is, you know, what is correct in the interests of justice, and it sort of shades in to the local public policy point where families, you know, the status, these are matters of public order, and I give the cites to the Constitution and the Civil Code, so that there's a limit to how much you can disaggregate the proprietary aspects of a divorce from the personal status aspects of it, when you see how they're intertwined. Getting feedback. So where there is an overlap of jurisdiction, we're stuck with the fact that the Joint Judicial Committee, under decree, the 2016 decree, which is modelled, as Justice Ali Al-Madani rightly observed, on the equivalent provisions in the Union Supreme Court law, which provisions the Court of Appeal in IGPL and Standard Chartered said give the exclusive jurisdiction to the Union Supreme Court to carve up jurisdictional disputes, so that you can't even go there, you can't even stay for 4 more. That is by decision of the Union Supreme Court, which binds all, is now the Joint Judicial Committee's task. So what I am saying is, don't throw up our hands in horror that there's nothing we can do about conflicting litigation. Because in my respectful submission, that unfortunately, the whole forum non-conveniens policy in the DIFC proceeded upon the misapprehension, starting with alliance risk transfer, that the Union Supreme Court never intervenes until there are conflicting final judgments. Now, the case that was decided in alliance risk transfer, which I'm afraid I haven't got a translation for because it's moved on, because you're now looking at Justice Wayne Martin in 5 and Lacan as to how the DIFC courts react within the Emirate of Dubai to the JJC. But the idea that the Union Supreme Court never intervened at any point until conflicting final judgments was a complete misapprehension, because the case cited was talking about a final judgment in England, I think it was England, but a jurisdiction outside the UAE, as against a final judgment inside the UAE, and all it stood for is that the Union Supreme Court had no jurisdiction to only resolve final judgments within the UAE. Didn't stand for that. So what actually happened in Maidan was that the proceedings here, Justice Omar stayed the proceedings in the DIFC, all the proceedings onshore were stayed. It went to the Union Supreme Court for 12 months or more, in which time the JJC was invented, and they sent it back saying, no, it's all JJC now. So if IGPL is correct, and I noticed there's a curiosity about IGPL, which I thought was just a transcript error, which is that the judgment of the court is given by Chief Justice Huang, and Justice Steele, and I think Justice Al-Madani expressed, sorry, not Justice Steele, is that the two other judges expressed agreement with Justice Sir David Steele at first instance, not with the Chief Justice's judgment. I had thought that that was a mere error, but it is noted in my learned friend's DIFC court's practice. So whether IGPL is, and to what extent it remains good law, is out there. But the point that I'm making to you is on a rather different tack, which is I'm not inviting you to say, as a matter of, the family courts are clearly the more convenient forum, because it puts me straight into the and puts your lordship straight into the no-go area of FNC, which has been got rid of not once but twice at Court of Appeal level. But where I do, in my respectful submission, say you can free yourself is from the misplaced notion that it will only be in rare and compelling circumstances that it makes sense for the DIFC courts to stay in favour of parallel proceedings onshore, because the context of in which the rare and compelling features had been misunderstood to be the test was whether there was a separate test for case management stays in parallel proceedings cases between proceedings pending in the UK or in England, proceedings pending abroad, most often in Europe. And as Lord Bingham had said, it would only be in a rare case that there'd be good reasons to stay. But that's in a circumstance where every case with foreign defendants would have gone through either the filter of permission, or jurisdiction would have to be there without permission under the Brussels Convention and then Reg, which performs an identical function to what the CPC does onshore here, and very similarly, because they've got the same civilian antecedents. So I say that it is that as a matter of public order, the abuse of process ground is nested in the public order ground, because just as you found that it was an improper collateral attack for David Haig to try to get damages for false imprisonment, a proper collateral attack, improper collateral attack on the bail decision of the criminal court. This, because it's a proprietary claim, is an improper attack on the final judgment of the matrimonial personal status courts, which have the stewardship function for amongst other things, for minors. And as I put it forward, is that that public policy consideration must be equally keenly engaged whether the parents are alleged to be saints or sinners. And one would say a fortiori if they're alleged to be sinners, if there was any neglect of any kind alleged, which I hasten to add is certainly not the case raised by anyone here, that these young lads are not being taken care of extremely well, and the dividend income that they had bequeathed upon them by the family court should have even provided servants, which is great. So that, I'm not suggesting for a minute there's any anything of that nature in it, but that's how the abuse of process ground nests into the public order ground, and then goes on in turn to the case management ground, which I can take very shortly, my lord, because
sorry to interrupt, my lord, and I've done that more than once today, and I do apologise for it again. I'm just concerned about time. I'm anticipating your lordship will want to hear from me on at least some of this, and maybe that's not the case. But my learned friend has been speaking for more than 3 hours now, in a 4-hour hearing. We are running out of time.
Fine. Well,
How much more have you got to go, Mr.
well, my lord, I'd rather, I don't want my learned friend to be under time pressure. There's no need that he should be, because I've set out the core point that I'm making in the when it comes to the case management ground is that no room for rare and exceptional.
Yeah, you've got that point. Yeah,
you've got that point, and because Rule 12 is specific with respect to eschewing the exercise of jurisdiction when you have jurisdiction. Judicial restraint, can't mention the F word, but plainly the proper form to deal with this is by courts, and makes much more sense in terms of the overriding objective to come out with a solution that packs the claimant off with any help that they need to intervene in the family courts to stop contesting the negative declarations on the basis of jurisdiction. And then, so far as the freezing orders go, is that in my respectful submission, we've got to come back to deal with that, and part of that bleeds into the ADR application. So unless I can insist any further, I will wrap it up there.
You better, if you want to say something about the ADR, then you better say that now, haven't you?
Sorry, my lord. When I had said that I'd agreed with my learned friend that we should do ADR at the end, I meant the end of everything.
Right.
And that's what I had in mind when I invited your lordship to not go into private or not.
All right. Well, let's just see where we get to then. So, subject to the ADR point, you said what you wish to say.
I have subject to the ADR point and just directions in relation to coming back.
Yeah. Okay.
And leave to appeal and all that, or permission to appeal being all, etc.
Yeah. All right, Mr. Montague-Smith, I'd like to hear from you in relation to the need for an extension of time. And then I will want to ask you some specific questions, I think, in relation to the effect of what's happened since the 5th of September judgment in onshore.
Yes. Thank you. All right. Can I just, before, and I will deal with the extension of time, that was the first topic I was going to take substantively, but I just wanted to frame it a little bit and just remind your lordship of a couple of things. The first point is this: when one actually looks at the application notice that we're dealing with, what is alleged is, yes, that this claim is in some way inconsistent with the onshore Dubai divorce decree. Yes, that is said, and that is said to be an abusive process. And it said, well, any attempt to set aside the divorce judgment should be made to the Dubai courts. That has obviously developed quite considerably. And obviously we say it is put as an application under Part 12. So the timing issue does arise on the basis of the way that it is put. But we say none of the grounds that are advanced really have anything to do with jurisdiction. And in particular, the way that my learned friend is advancing his application today is predominantly as a JJC stay application. No one has ever said that is a ground for not exercising jurisdiction, and there's a logical reason why it can't be, because on the authorities you don't get a JJC stay until both courts have actually accepted jurisdiction. There needs to be a positive acceptance of jurisdiction. So the idea that a JJC stay is a reason not for this court not to exercise jurisdiction is logically incoherent. But in any event, you've heard so much about JJC stays. There has already been a series of applications. You were shown the conclusion of those applications on the basis of the JJC decree. So Mr. Manners has had his chance to make those applications and has failed on them. You can't just come back to court and say, oh, well, I want to argue a different point. And actually, the way that it is put is also incoherent, we say. I just preface it with that. So I will deal with the timing of the application. That there are two questions there. Was the application in time? And if it wasn't in time, should there be an extension of that time? I was going to deal with, as a second point, explaining why this court has jurisdiction over the claim, but I think your lordship has that point as a freestanding jurisdiction. I was going to go on to deal with whether this claim is an attempt to dispute, if I can put it like that, the divorce decree, the inconsistency point. But obviously I can be led as to whether you want to hear from me on that. But then I was going to go through the various ways in which it was put. But you've asked me to deal with timing, so let me do that first, and then you can ask me whatever you like, obviously.
Thank you.
Obviously, it was prefaced with obviously, and what I meant was I won't force submissions down your throat that you're not interested in hearing about. There are a number of ways that this is put. The first point is that the application was made in time, and my learned friend points to prior applications that have been determined against his client as somehow establishing that this application was made in time. So your lordship's been made aware of and has determined the jurisdiction application in relation to the Part 8 claim. So my learned friend says, well, somehow he can rely on that as saying that his fresh jurisdiction application's in time. But obviously that doesn't work. It doesn't work for a number of reasons, not least because that application was specific to the Part 8 claim. It was about the service and the process of that claim, so as I understand the submissions, he seems to be saying, well, that you can rely on the fact of that application. But at that time, there were two different claims. One was a claim for the injunction, and that had to be made by Part 8 because it was pre-action. The other was a claim for the substantive relief, and that's the Part 7 proceedings. So at the time that that application disputing jurisdiction in the Part 8 claim was made, both claims were on foot. An application disputing jurisdiction was made in one, but not the other. This was at a time before they were consolidated, and they were ultimately consolidated in June of this year, after time had expired for disputing jurisdiction in the Part 7 claim. So there's no procedural way in which he can rely on that. In his outline submissions, he relies on various other factors. So he says, for example, in his outline submissions that on the 25th of May, the first defendant filed an application to dispute jurisdiction. But there he refers to application 3 in the Part 7 proceedings. Application 3 in the Part 7 proceedings was a JJC application which was dismissed.
It doesn't help me to refer to them by number, I'm afraid.
I understand. I can show you it if you like. It's at bundle J, tab 69. That's the application notice that my learned friend refers to as the jurisdiction application that was made in the Part 7 proceedings. So I mentioned page 2580. It's the very first page of J, section J. So this is the application in the Part 7 proceedings, and I'm afraid the number why we know it is from the application notice. You see CFI 030. That's the Part 7 one. It's 021. The earlier number is the Part 8. You can perhaps remember it like that. Earlier in time, we had to make the Part 8 first, and then we made the Part 7. Yeah. So you see down at Part A, the application is the JJC application. And that is the application that was dismissed. And you've already seen the order by which it is dismissed. But if we just remember the number 3, because that's obviously how it is referred to, you see it at bundle C, tab 32, page 318. That's the order which recites and refers to this particular application, I'm afraid, by number. And then dismisses and defines all of those 4 applications as the JJC stay applications. This is page 318. And then page 319, you see paragraph 2, the JJC applications are dismissed. So I just clear away that allegation that was made in the outline submissions, my learned friend's outline submissions, I think it's in the bundle at page 50, little g, but in any event, sorry, on page 52, little g. I think what that shows is two things. The fact that my learned friend made that application, you can't rely on that as establishing that his later application is made in time, but I think it also reveals that what he's genuinely really doing is trying to rerun that application. And some of the confusion is sown because in support of this new application that he makes, he relies on the old evidence because he simply refiled his first, second and third witness statements. And those witness statements were directed at the JJC application. I can take you to them if you'd like me to, but it doesn't much. I can summarize it like this. The first witness statement, which he relies on, was directed at seeking the JJC stay in the first place. Then the second one, which he also relies on in support of this application, was an attempt to challenge the listing of the set-aside application in relation to that. And then the third was to oppose the set-aside application itself. So they were all directed at the management of that JJC application number 3. And what he's done is he's just made his new application and reproduced those witness statements. But he failed on all 3 of those applications. And he relies on that material, again, effectively to try to make his JJC complaint once more. And so what he said today, as I understand his submissions, is that because he made that those earlier applications, and because they were made within the time limit for making a jurisdiction dispute, then somehow this current application is in time. And the other thing he said, and that I say just incoherent. Firstly, a JJC application is not a Part 12 application disputing jurisdiction at all. And I'll explain why I say that. And secondly, as I say, because in relation to the Part 8 part of it, the one that your lordship has now dismissed, there was a separate process, a separate acknowledgement of service and so forth. And by the time that the proceedings were consolidated together, that's June, he had already missed the deadline for disputing jurisdiction in the Part 7 claim. The reference to the June consolidation order is at D tab 29, page 313.
Well, the point that really interests me from that point on, assuming for these purposes only that I accept your submissions, is whether in such circumstances, because there had been an acknowledgement of service that suggested that jurisdiction was going to be contested, there ought to be some relief because they haven't actually gone ahead and issued the necessary application in accordance with 12(1)(4).
Yes, so the sanction is, I think, 12.5, which says you're treated as submitting. The question, yes. The first question is, what's the test? Because I think at one stage my learned friend was saying it's not relief from sanctions, and I think he was relying on a passage from a Privy Council decision, which suggested Lord Collins suggested that wasn't the position. We now know it is the position. It is a relief from sanctions application, and the case for that is Apex Global Management. I can take you to that if you'd like, my lord. It's at bundle L, tab 93, and page 2976 is the relevant passage.
Page
2976.
Thank you.
And so you'll see paragraph 15, the issue arose as to, well, paragraph 14, you see the issue arose as to the test. Paragraph 15 cites the relevant bits from Texas Management, which is the Privy Council case my learned friend was previously relying on. And paragraph 16 says this: subsequently in Zumax, Nigeria, Lord Justice Kitchen confirmed that contrary to certain observations of Lord Collins in Texan Management, an application for an extension would be treated as an application for relief from sanctions, and goes on to explain that that has been followed and that's now established in England. And that is what the Deputy Chief Justice, His Excellency Ali Al-Madani, that's how he treated a similar application by Ms. Zilla. So Ms. Zilla also made an application late to dispute jurisdiction in the Part 7 claim, and she was refused permission. And we can see that decision. It's in bundle F behind tab 53, and you'll find the relevant part at 1465. It starts at 1456, but at 1465 you see the reasoning for it. Well, sorry, 1464 is where it starts, and he treats the application for a retrospective extension of time to dispute jurisdiction as an application for relief from sanctions, and goes on to look at the Denton criteria. So you have there, albeit in the same action, but between different parties, a decision of the Deputy Chief Justice in this cause, which isn't obviously or clearly wrong, and therefore convention would say your lordship should follow it. But that is the way that it's approached in the Court of Appeal in England. And so in this case, the delay of Mr. Manis was actually slightly longer than Miss Zilla's delay, because he applied on the 8th of August, whereas Miss Zilla had applied, I think, on the 5th of August. There's a few days, I accept it's not hugely significant. But the reason we say that the reasons that the Deputy Chief Justice gives here for refusing an extension for Miss Zilla are all apply identically in our case, and then there are a few other reasons which apply in relation to Miss Manis. So the first question is paragraph 41, is it a significant and serious breach? And he said that it was. We say the delay is about 3 months. So should he have, and then he goes on to say it caused a waste of court and party resources. Paragraph 42, why did it occur? Because obviously that's the second phase. You need to understand why it occurred. In our case, we have no explanation whatsoever. Now, in Ms. Zilla's case, her primary position was that no breach occurred, but he says, well, the judge gets the impression that she didn't understand the rules, but that wasn't a good enough reason. The slight difference.
She was represented, was she?
She was represented. She was by Galadari. And Mr. Manis was also represented at this point by KBH. And he did.
That's a fundamental point here, isn't it?
Yeah.
You know, on the face of it, it's very well known what the effect of not making an application is, and certainly lawyers who practice in the DIFC should know that. I'm sure they do.
Yes. Right. And the other point to make is that the fact that he made an application in the Part 8 proceedings indicates that this is a deliberate decision that was taken.
Yeah. Okay.
One application was made, one was not. And the reality is bad points were taken on the Part 8, but there were no good points to take on the Part 7. There's no substantive dispute, real basis for it. So it's a deliberate decision. It's caused delay and so on and so forth. And the other point the judge makes is that it's still open to Ms. Zilla and also to Ms. Manis to go to the JJC, so they're not shut out for all time. It's ultimately a case management question. The judge was also concerned at paragraph 47 about 3 other factors. The one was that Ms. Zilla was trying to stay the claim against Mr. Manis as well. So there's a certain degree of collusion too. Reading between the lines, one might say that's a questioning in effect the bona fides of the separation of the two, and we say that goes doubly here. And the second point is that we could progress the claim without her anyway, but that we can put to the side for now. And the third was that she had carried on with the Dubai proceedings. She tried to pursue those, and Mr. Manis has done the same. He ran his counterclaim. The other points we make in relation to Mr. Manis are these. First, we've already litigated against him at considerable expense for a very long period of time.
Yeah.
He's got a track record of lying to the courts and moving his assets about. We should be entitled to move quickly and with the least expense, particularly as we've seen, because there's no defence to the claim. That's the first sort of set of points there. The second point is a legal one, which is that there is a line of authority that says when you're considering whether to give relief from sanctions, the respondent's prejudice is not just the prejudice from the delay, it's the prejudice from taking away from them the benefit of the sanction. So this often arises. Yeah. So it often,
right.
I'm sorry?
A vested rights point, if you like.
Exactly. And so it usually arises in the limitation context.
Yeah, quite.
And the answer, often the problem is put, well, I need an extension because otherwise I'm shut out. And the response comes back, yes, but if I give you an extension, you're no longer shut out. And now the party has to face this action. And that has been described as a very powerful point by the Court of Appeal in England, a very powerful reason not to. And so it should be a powerful factor here. And then the other point is simply that you have no evidence whatsoever from Mr. Manus. None. Yeah. No explanation, no evidence. He can't explain the delay. He can't justify the relief. So in the High Court in England, this would be a very straightforward and simple application. You wouldn't get started on relief from sanctions. The rules are designed to follow the High Court in England, and we should take that approach. That's all I was going to say on extension.
Right. The next question really is this, that assume again, just for the purposes of argument, that I'm with you thus far, so there's no room for an application under RDC 12, 1 or 2. Effectively, what that leaves is the argument there should be a stay on, quote, case management or abusive process grounds. I know you say this is really only dressing up a jurisdictional point, but leaving that aside for the moment, what do you say is the effect, if any, of what has taken place in onshore Dubai since the 5th of September?
It doesn't have any effect because there are two parts to the test for a JJC stay. One of them is that the substance of the claims must be inconsistent with one with the other. And then the other is that sufficient steps have been taken by both courts such that there qualifies as a dispute of jurisdiction between the courts.
Yeah.
And so the steps that have occurred in Dubai courts since that judgment could only affect that second question. And what you need to establish a dispute of jurisdiction between the two courts is a positive step by both courts, which give rise to a conflict of jurisdiction. Your Lordship is well across the authorities on this and knows all about the Dubai Islamic Bank, DIFC investments in Dubai Islamic Bank, but that was the conclusion of the review of the authorities in that. So what you would need is for both courts to say positively, we have jurisdiction.
Yeah.
And actually what's happened is that this court is being asked to answer the question, do we have jurisdiction? Answer yes, if this arises at all. And then as to the local court, the only answer we have is no. So the fact that somebody challenges that doesn't give rise to a positive determination by the court that they have accepted jurisdiction.
Yeah, very good. All right. I don't think I need to hear anything further from you, Mr. Martin.
Your Lordship doesn't want me to say anything on the question of the effect of the onshore divorce decree, just to be clear.
Well, is there anything you want to say over and above what you've already said to the Lord Glennie?
Other than to say, your lordship was quoting from an older textbook. I can give you the reference to the passage. It's in the bundle of the relevant rule, if that's helpful as to the effect of in rem rules. It's Rule 50. You'll find it at Bundle L, tab 110, page 3334. I'm afraid in light of my learner friend's submissions, I did also include authority as to the locus of shares, but I think you can take that as read. And that's it. Oh, and the only other point I wanted to make was it's quite clear that this court treats maintenance orders and financial orders in the context of divorce as in personam orders when in the question of when considering whether to enforce them. How do we know that? We know that from the Akhmedova case.
Oh, well, okay.
Well, if your lordship recalls, the Akhmedova case was about this question of the enforcement of. Maybe that your lordship can still hear me, but you've frozen. Yeah. Okay, very good. The Akhmedova case was an English divorce that was sought to be enforced. Yeah, exactly. And there were some findings in the English divorce, but the way that it was treated was as an in personam set of rights which needed to be enforced in the diocesan courts as between the two parties, not as an in rem, some sort of in rem.
Yeah, but what order did the English court make? I don't recall the details.
They made an order for financial relief, I think.
Yeah,
but they also made certain. Yeah.
But not specifically in relation to any item of property.
No, I think that's fair. That's fair.
Yeah, and it's a different point, really.
It didn't arise in quite the same way, but the point I'm making is that when you're looking at a divorce, there are two potential aspects to it. One is the status in which the court at the place, in various places, according to different set of rules we haven't looked at yet, might well be considered to have jurisdiction to grant an in rem decree as to the status of that marriage. One can see that, but that's quite separate from the other part, which is the financial provision that often goes with that decree, but is an in personam inter partes obligation imposed by one on the other.
Is Akhmedova in the authorities before the court?
I don't think it is.
No. But my recollection is, and tell me if I'm wrong, my recollection is that it was, I mean, the order simply made, the English court order provided for a sum of money.
I think that's right.
Paid from one to t'other, that's all. So it didn't impact on any particular property of any kind.
I think that's right. Yes.
Yeah, so it's rather different from this case. Yeah.
Yes, it is. But I think that the question, what it does is it shows us that insofar, take the position that we accept that the English court had jurisdiction over that marriage, and could make an in rem determination in respect of that marriage.
Yes.
That in rem character does not also continue across into the orders for financial relief. They're just treated in the same way. They're treated quite separately. And
I think it's implicit in the rule itself. You know, the status of the marriage self-evidently is an in rem thing.
Very good.
Yeah. All right.
All right. If your lordship doesn't want to hear me on anything else, then I shall leave it there.
I don't think so for the moment, at least, unless there's something that occurs to me later.
There was
the only other question is this, Mr. Montague Smith, is exactly what I'm dealing with today.
Yeah.
In terms of the freezing order, I think both parties agreed that goes off for another day. Is that right?
But there isn't actually an application in relation to the freezing order. We say that there's an issue about that, and it's this. As to, if I can show you just the terms of the order itself, you'll find it at Bundle C, tab 23, and page 282. If your lordship goes down to 287.
Yes.
And paragraph 11.
Yeah.
So again, my own friend needs relief from sanctions. to make any kind of discharge application, or he needs to show there's been a change of circumstances. But as things stand, there's no application before you today, an application been made by my learned friends to vary or discharge the freezing order, other than by reference to his Part 12, other than as flowing from his jurisdiction complaint.
When the whole thing would go.
When the whole thing would go.
Well, it wouldn't actually, would it? I was going to say, because if I ordered a stay, that wouldn't impact on the freezer at all, would it?
Well, it depends. I can see if you were to be you being invited to determine for all time that you will never exercise jurisdiction over this claim on a sort of forum non basis, then one might say, well, there's no point in maintaining it. But yes, I mean, other than as consequential on the jurisdiction application, there's no application to vary. It's crept into my learned friend's skeleton argument as something that simply must be done. But actually, it's far too late, at least for his clients, to make that application. He doesn't have an application, and there's no evidence in relation to it anyway. So if he wants to try and come back, we'll say it's an abusive process, but it's not for today.
All right. Mr. Taylor.
Yes, my lord. Two quick points in reply on the timeliness point. One, which it's a very short point, but that I did not mention in opening, which is if my lord could just turn to the JJC decree at 3612 in the bundle. And apologies for not saying this, because I appreciate my learned friend didn't have an opportunity to respond on it. But if you look at Article 6,
yes,
suspension of legal time limits, of course, the Lacan debate was focused primarily on the requirement to stay the proceedings through the operation of Articles 4 and 5. What Article 6 provides for separately is that legal time limits, as well as the prescription periods provided in the legislation in force, should be suspended from the date. Now, I think what one would say here is that the RDC...
You've got a 6-week lacuna.
Well, no, it's not even the 6-week lacuna, because as long as it's before the JJC, is that what I say is that the requirement, which is now one that one is to get relief from sanctions on, is one of the rules of the Dubai Court, which is a DIFC law / regulation, and Your Honour will recall if you don't, I'm afraid I don't think it's in the authorities, but if you recall in Nest at first instance, Justice Roger Giles had made some distinctions as to whether the rules and the necessary proper party ground could be, as it were, jurisdiction conferring, which in the Court of Appeal you said they could, and I think, my lord, you were on that appeal. So what I would say is that, quite simply, the JJC decree is one that the court can and does consider, and I think the basis on which my learned friend would put it is that the JJC decree, being a DIFC facing, well, it's Janus facing, but includes being DIFC facing Dubai law, like the judicial authorities law, is a DIFC law which it can construe, and that what it is doing is mainly and certainly aiming at prescription periods, but it is talking about legal time limits, and the legal time limit on which my learned friend hangs his hat is, of course, the mechanism in Rule 12, and it is, I think, just worth turning up. And I don't know if my lord has it most easily in the rules to hand rather than in the bundle, but my point here is that my learned friend did say, and maybe I missed something, but he did say that he was going to explain why a JJC stay claim could not be counted as a claim for the purposes of Rule 12. And I fail to see why not. So the first point under Article 6 is that Article 6 creates a stay of those of the Rule 12 clock anyway, and that furthermore, a fair approach to Rule 12 that accords with common sense is that 12.1 refers to a defendant who wishes to either dispute the court's jurisdiction to try a claim, which we're not doing because that's 12.1, or to argue that the court should not exercise its jurisdiction. Now, I don't understand why saying that the court should not exercise its jurisdiction, because this is going to the JJC, doesn't count as far as the second limb of Rule 12.1 is concerned. The final paragraph of 12.1 is permissive in the sense that you may apply to the court declaring that it has no such jurisdiction or should not exercise any jurisdiction which it may have, but which is compendiously a jurisdiction challenge.
What you've just said, I think, gives rise to.
We've lost
automatic. I'm so sorry, Mr. Taylor. There's an inherent inconsistency, isn't there? Because if Article 6 has the effect of suspending legal time limits so that nothing applies at all, you don't need to have a stay of any kind. You don't need to apply under Rule 12 at all. Automatically, everything would simply stop. And we know that's not the effect because of Lacan and everything else.
Well, I understand that tension, Your Honour, because, bear in mind that what the pre-Lacan jurisprudence had been was that everything simply stopped and that you couldn't even make an application. So I think one has to differentiate, and in construing the decree, the differentiation is between the process and time limits that are in the process, and and prescription limits. Now, again, one has the difficulty there is that, as Your Lordship will recall, before the Foreign Limitation Periods Act was enacted, is that as a matter of private international law, the question of whether a time limit was applicable, foreign limitation period was applicable, required an analysis as to whether it barred the right or barred the remedy. Now, what I submit that Article 6 is driving at is that it is certainly driving at limitation periods, because you imagine a case such as this where there has been a Part 8 claim to get interlocutory relief in advance of a Part 7 claim, the way that would have been done in the old days, on the basis of an undertaking to issue. Unless and until you'd issued your writ, you wouldn't stop time running. So if a JJC procedural stay had come down so that with respect to the same dispute, they got their Part 8 claim where they could bang a freezing order even on to the side of substantive litigation anywhere else. And I understand that the DIFC courts swallowed Convoy whole and is doing that now, is that you wouldn't want the stay and the inability for someone to issue Part 7 claim to stop them from stopping time running for a limitation defence that, never mind how you analysed it, but would extinguish a substantive right in this forum. Whether it had barred the remedy or barred the right seems to me to be angels on the head of a pin, which is why the Foreign Limitation Periods Act said no. Circumstances where the applicable law prescribed limitation should be regarded as substantive. It gets rid of that analysis. Now, that in turn raises the question as to what is the nature of the right to say, I shall not have jurisdiction exercised over me. On the one hand, one's saying, fine, we're swallowing whole post-Jackson relief against sanctions, and that you've got to get on or you lose your rights. And what, on the other hand, you're saying one reason is because you're depriving someone on the other side of the coin. If you extend their time, you're depriving them of an accrued right. Well, what, just as if a claim was time barred because the procedural stay under Forum 5 stopped the issue of a writ, I would say that the Article 6 suspension of time limits should apply to the time within which, as it has become under 12.4, an application on this part must be made within 14 days. And my lord, I had forgotten that the evolution of this since conditional appearances, etc., is that in the CPR, it had migrated, and hasn't, I think, migrated in Cayman, from the need to file your acknowledgement within the time set for filing your defence. That was changed to 14 days, because otherwise, in the present case, what would have happened is that the immediate judgment application stayed time for defence, and it would have automatically extended the time for a jurisdiction challenge under the old regime. This is now a 14-day cutoff. My point is that looking at whether they've barred the right to say that here a court with a limited statutory jurisdiction should exercise its jurisdiction over them, is that time limit should stop running under Article 6 anyway, point 1. Point 2, that the challenge, or that saying don't exercise jurisdiction because this is going off to the JJC, should count for the purposes of 12.4. That yes, you did have the 12.4, you did have an explicit Rule 12 challenge in the Part 8 claim, which came to be consolidated. I accept that all that was driving at was the service point. Now, perhaps what one might have done would be, rather than issuing a fresh application in circumstances where this was all about as clear as mud to the DIFC courts, as well as to the registry, to the litigants, and everyone else. Justice Wayne Martin, I forget in which of the cases, says that it was his mistake issuing a blanket stay. well, it's not something I've often heard said, that it's a mistake, but I mean, it just shows that well, I say it's repugnant to common sense. It's absolutely plain that whatever the procedural nitty-gritty is, that these defendants are saying, don't exercise this jurisdiction. It belongs in Dubai courts, and we're going to the JJC, which is the statutory tribunal that deals with it. And so to exercise this kind of gotcha seemed to me to be completely wrong. And that even though I fully accept that Mr. Justice Ali Al-Madani has applied the sanctions analysis to it, is that what is missing from the equation as to it, when a learned friend says that the CPR should be followed, sure, but the formulation case management stay in the RDC has remained pre-Jackson and has not come to the formulation that was considered in Denton. And I just would respectfully submit that this is, it is wrong to take this gotcha approach to jurisdiction when what is at issue is within the Emirate of Dubai, which court should be dealing with this. JJC decides, but you know, the saving of cost is that if you can proactively case manage in the DIFC without artificial barriers of no forum non-convenience, no requirement for circumstances that are rare and exceptional, then you can avoid a lot of these costs. Because the subtext is that if anyone that wants to go off to the JJC is automatically a bad person. Appears to be. I mean, that's what the ruler of Dubai has inserted to make sure that jurisdictional conflicts stay in Dubai, not in Abu Dhabi. So, you know, I'm sorry, I've been longer than I intended to, because it comes down to 2 points. One is, I do see the earlier challenges as being timely and counting for the purposes of Rule 12. And two, I submit that Article 6 should stop those time limits running, regardless of whether there is a stay of the proceedings. And then I've now forgot the other point that my learned friend addressed. I wanted to say 2 words on. No, I think there was. No, it was in relation to what is to be done about the freezing order.
Well, you say it's a matter for another day, so that's.
It is a matter for another day, and well, you know, and he is right that it is addressed at the moment only as a result of only as part and parcel of the jurisdiction challenge. I had wanted for there to be a case management conference precisely so this could be addressed and dealt with, but now it should go over, and that the ADR application is relevant to that as well because of valuing security to get rid of the freezing order.
We'd better deal with mediation now, hadn't we?
I think so, Your Honour.
My lord, before we do that, do you need any help from me on Article 6? It seems to me there's a very short answer to it.
The legal time limits provided for in the legislation shall be suspended.
Yes, from the date of filing the motion. So I think my learned friend says, I mean, that what he's saying in result would be a stay, and as your lordship has pointed out, that would be inconsistent with Lacan. And so we have to interpret this properly, and the way to interpret it is to see that Article 6 can only apply if there is a conflict of jurisdiction within the meaning of Article 4. So you get Article 4 requires the conflict of jurisdiction, and that's been interpreted. Article 5 says the consequences of referral are 1, 2. in accordance with the provisions of 4. Article 6 adds the suspension of time limits. So it can only be flowing from those two articles. And so the way to interpret the suspension is as arising only when there is that conflict of jurisdiction.
Well, I think that's problematic, Mr. Montague-Smith, because that means if you're wrong in making the application, all the time limits run against you
Yes.
in relation to putting in a defence and everything else.
But
I should have thought the answer
Sorry.
surely is that it's legal time limits provided for in the legislation. Doesn't apply to rules of court at all.
Well, yeah, perhaps that's right. Perhaps that's right. But I would say actually all the time limits would run against you anyway, wouldn't they? That's the consequence of Lacan. If you're wrong in making the application. There's nothing wrong with that conclusion.
Yes, but it doesn't seem to me that's what Article 6 is. Article 6 intends that on its face that if you make an application, unless it's made in bad faith and there are all sorts of other reasons, on the face of it, time limits are suspended until the JJC makes its decision.
Oh, I see. Well, I mean, I'd press for the other part of that interpretation as well, though, that must always be subject to there being a relevant conflict of jurisdiction. So you have to assume that it's all running unless and until you get that conflict. And it's once the conflict arises, then there is some sort of stay of all time limits in the legislation. But there we are. In any event, it can't mean what my learned friend says it means, otherwise he has to go through Lacan.
Well, that's the difficulty about it. But I'm not sure that anybody's ever looked at Article 6 quite in that context, have they? I don't recall whether it was ever discussed in any of the previous cases.
No, I don't think it's featured in Lacan or any of the other ones.
No. Right. Mediation.
I couldn't see it either. Mediation, my lord. Presumably, it is uncontroversial that there is a pro-ADR bias at first blush, and that the questions then become in making this form of ADR order, which is modelled on what was once called an Ungley order, although I see that Ungley orders seem to have disappeared from the White Book, where ADR now occupies many, many pages, which it didn't, is that the debate, the key debate that has gone on in the UK is really twofold. One, what in the mediation business I think they call the horticultural phase, which is that based on what two things that were said. One, Mr. Justice Macduff, who said that leaned against court-ordered mediation on the basis that you could lead a horse to water,
yeah,
but couldn't make it drink. And I can't complete an open court, Dorothy Parker, including the word horticulture in a sentence. But the point is that it is the mediator that has to do make the parties drink or think, depending what you're doing. And what the court is assessing is whether there is case management utility in the interests of the overriding objective to proactively encourage settlement, to the extent, in particular, of whether they grant a stay and send people off to mediation. And then the debate is about what consequences should follow, and should there be sanctions, etc., and not having satellite litigation. What has been said on behalf of my learned friend's client is that they don't wish to be ordered to mediate, as I understand it, because they're not satisfied that my client is serious and that he isn't just doing this for delay, etc. What I would have regarded as the utility of mediation in this process is that it shouldn't hold things up beyond period in which I would want this to go away. I mean, it depends whether my lord is planning to reserve, or as you so often do, go out for 15 minutes and come back with an immaculate extempore judgment. But if my lord was going to reserve on the at least the stay, even if immediate judgment is to be entered now, that it would make sense for the matter to go away and come back with reporting from the parties in the terms of the draft order I've got, when, as I suggest it should, this matter should come back for a hearing. One, because you've got permission applications flying around all over the place. Well, so let me be a bit more precise about that. Presently, there is the second defendant has made a permission application against both the extension of time refusal and the set aside. My client has not sought permission, but within the rules is to be regarded as a respondent who would have to serve a respondent's notice if he was going to resist permission on the same timeline as the claimant is on. Sorry, let me just kill that phone. Apologies if I haven't one second. So I believe that there would be utility in the mediation, if only to agree, because the order provides for 18 million of security to be put up in cash, or security in a form that is agreed. So there's questions of value and amount. As set out in the ADR skeleton and the first defendant's, in my respectful submission, very frank email saying, understand, look, this is, he has been found to be liable for a judgment debt. This is now an enforcement dispute. It's a question of what assets were attached, time to pay, etc. Very different dispute, with what, in my respectful submission, is quite a remarkable feature, that for the judge who conducted the trial for 14 days or more to be willing to mediate, and the first defendant being prepared for him to be the mediator, is a factor that should weigh heavily in the balance of having a go. So, Your Honour, I would propose that a mediation ought to be made in the form that I've asked for, which also deals with the possibility for this to come back at a hand-down hearing. That anticipates that one would have been kept in suspension as to certainly what my Lord's decision would be on the outcome of the, not necessarily the IJ application, where my Lord has made his position pretty clear where he's minded. But beyond that, I would say if you're going to give immediate judgment, it should be a stay of execution of the money judgment anyway. That the Crown ordains that. Oh, and the last point I'd make is that when it comes to positive acts, don't let it, sorry for doing this, is not mediation, but it's escaped my attention to say this, is that the divorce judgment was a positive act taking jurisdiction. And the dividend freeze and the freezing order was also a positive act. And you've now had the Rule 12 hearing, so that the timing point, which was all that Justice Ali Al-Madani dealt with, don't think my learned friend would contradict that, is history. And what you're dealing with now is there a conflict? So I think if there's going to be, even if we're left in the dark as to what the reasons are, because you would come back, and I've given suggested directions about fixing something for a day, that would enable submissions to be made. The judgment would be released as a draft, as the commercial court practice, rather than just coming out, which would enable all permission applications to be heard orally. That was what I had in mind, and the mediation would happen in that interval, and that the parties would report back. Obviously, if the whole thing's settled, it's gone. But there's a sort of halfway house. They may get very close to settling, or may agree the form and value of security to be put up. Because as I said, I wasn't going to waste the court's time or my breath on trying to say there is no evidence of a serious risk of dissipation of assets that can be squirreled away, but the restaurant is not such. There can be a stop order on the shares, and we say the dividend freeze should go. There could be some, that's what I would want to come back for on a proper application, with obviously the second defendant needs to participate if that's going to happen. That's what I'd hope would happen at a 1-hour case management conference that I'd sought in application number 7, but was simply never listed. Unless I can assist further, that's what I have to say about mediation. And
Thank you.
Your Honour, you've plainly read my client's written statement on that in detail. Yeah.
Yes. Well, I'm going to tell you the result, but not give you the reasons. The reasons will come in writing, but I'm not making any order for a stay on any of the grounds put forward, including the mediation possibility. I'm giving judgment in the context of the various prayers for relief at the end of the particulars of claim, meaning 1, 2, 3, and then I'll listen to what the parties say about interest. And the question then arises as to what directions are to be made for the future. 2 points I note in relation to the potential directions for the future. And one is the position of the second defendant, who does not want to make any oral representations in relation to her applications for permission to appeal, so said in a letter from her lawyers, which I have somewhere but can't now find. And the second point I was going to make in relation to that is that she has not committed herself to any mediation of any kind, saying only she'd be prepared to consider it subject to questions of detail. But I see no future.
We lost you there, I'm afraid. Sorry, my lord, we lost you for a few.
I see no case management utility, to use Mr. Taylor's expression, in ordering a mediation when the claimant does not want to participate in it, suspects the first defendant of acting in bad faith, wanting more time to squirrel away assets or whatever, and can't see that mediation will therefore provide any solution at all. If there's to be an agreement about value of assets or security to be put up, both parties are represented and can approach the matter with, one would hope, commercial common sense. So what's left now, and I'm conscious of the time because of the court staff, but what's left now is simply a question of what directions ought to be given for the future. Start with Mr. Montague-Smith in relation to that.
Thank you, my lord. I've set
You
out.
want to deal with interest first, actually?
Yes,
That would be
let me deal with interest. Thank you. So
Right.
the interest that is sought is pleaded at bundle C, tab 26, page 6 of the paragraph 6. It's on page 305. Sorry, and you'll see why we seek the interest at the rate we see is in the judgment. We were ordered interest at 5% on the sums above. I can show you that in the judgment itself. The judgment itself you find at K, tab 74, page 2703, paragraph 5. I have an interest calculation. I haven't shared it with my learned friend. But today's date on the euros, we get the sum of 458,122.55. And on the 2.6 million, we get interest to today's date of £95,095.89. I've got that converted into dirham if you want it, but otherwise those are the sums that are being sought.
You haven't had a chance to look at this, Mr. Taylor.
I have not, my lord.
Well, I think the answer would be to give judgment as at today's date with interest that runs to today's date. So you can share that calculation with Mr. Taylor for his verification. And if there's an issue, he can come back on it.
Thank you.
I'm grateful, my lord.
In relation to, sorry.
So I mean, to the best of my understanding, there's no. It is a matter of calculation.
Exactly.
I haven't. I confess, got fully on top of what rates of interest are running from when and to when, and whether there's any duplication between the London judgment and the DIFC judgment, because plainly the sitters of the debt is the London debt, and one would not want a situation where interest is running on the same principle under two judgments at once. I mean, there would be issues that might arise, and I just would need to get my head around that. But hopefully there'll be no problems other than maths, which is always a problem for me.
No, I probably took it too quickly, my lord. The basis for those interest payments is the judgment in England itself.
Yes.
And then that will then be converted into a DIFC judgment as of today's date. And then interest will continue to run on a different basis from that date on that sum, on the sum that is currently due. And so the interest that runs going forward will be then judgment interest on the judgment, if I can put it like that. So the 5% interest runs from January to now. That's because the judge said that's what should happen. And then going forward, on the sum that your lordship enters in judgment, there will still also be judgment interest under the normal statutory scheme.
No, I'm not understanding this now.
No, I'm not either.
Montague-Smith, we've gone too fast. I'm looking at paragraph 16 of the judgment, the order at page 2704, right?
Yes.
Simple interest. Oh, that's cost. Sorry.
No, sorry. It's at page 2703, paragraph 5.
Yeah, I'm sorry, I've lost that. So that's because it's a euro rate as opposed to. I'm just trying to work out what the judge was doing. And ordinarily, you would have expected judgment interest to run at the judgment rate, which I've no idea what it is in the UK now.
Yes.
8%, is it?
I don't know, actually. I'm afraid I just don't know. I haven't
Anyway,
looked into it. So simply because it's 5% is
the
what was ordered.
court
that's all
has
they're asking.
the court has discretion to order something different and has. So that's what ought to apply. But what you're saying is that once we get to the judgment date here, there's a different rate should apply thereafter because the judgment is in dirhams.
Well,
Right?
yes. I mean, so conceptually, all of these provisions in the judgment resolve down into a number as at this date for this court.
Yes,
and then it's in your lordship's discretion as to what rate of interest should apply going forward from there. It is just the judgment rate, and I think what we have asked for in on. Yes, sorry.
The problem, though, is, as Mr. Taylor says, that if you've got extant an English judgment that is saying 5% until payment, that will continue to run until payment, and there can't be any conflict between that and the judgment that this court gives.
Understood. In which case that militates in favour of a 5% interest rate continuing thereafter, which I wouldn't oppose.
Yeah. And 5% that runs on the principal sum in the UK judgment all the way through.
Otherwise,
Yes,
it's
don't get
not simple interest.
Otherwise,
Yes,
you get a cumulative basis of interest.
All right, I understand, and I will do a
Could have been
calculation.
awarded, but wasn't. But I
Yes.
think the whole basis upon which this court recognises the English judgment is that its terms continue to apply regardless, and you don't get an uplift of any kind, which otherwise you might.
Yeah.
You follow? Yeah,
I do.
so it will be
The cost is slightly different in relation. Sorry, the interest rate is slightly different in relation to the costs because, as you can see in paragraph 15b, it's the judgment rate, which is the 8%. So I have to say I simply don't know why.
It seems to me that one ought to be replicating the terms of paragraph 5 and paragraph 15 in the judgment that's going to be entered in DIFC, because what we're doing is simply recognizing and enforcing the English judgment without in any way changing its terms. That must be right as a matter of principle.
Well, that's very helpful. Thank you, my lord. And I don't think either of us disagree with that. I don't see any my own friend wants to make a contribution.
No, sorry, I certainly don't disagree with the principle. But
yes, quite.
But I can see
if you can work out
additional questions as to.
Well, why don't you draft something, Mr. Montague Smith, and send it to Mr. Taylor for his approval and agreement, if possible. If not, it'll have to come back to me. But what I'm clear about, what I'm trying to do, is to enter judgment as of today, which simply puts into effect in the DIFC the terms of what Sir Michael Burton awarded in his last case as Deputy Judge in the High Court.
Thank you. Yes, that's very clear, my lord, and I will do that.
Right, so that's okay.
Directions.
So
in our skeleton argument, we set out some directions, paragraph 89 that we proposed. I think preface this by saying this case has been somewhat held up and it's been held up by the JJC applications and all the rest of it, and the many applications that have been made since. I think we're up to 9 from my learned friend and some more from Ms. Diller. So we had suggested 14 days for a defence, and then shared document production 14 days later, with responses 7 days later and replies 7 days after that. Obviously, we're not going to tie the court's hands as to how quickly the court deals with document production, but once that is decided, then production of documents within 7 days of the court's decision. In relation to experts, we suggest that there might have been need for expert evidence. Now, the need may or may not depend to an extent on your lordship's decision today, because it may be that your lordship takes a view on certain aspects of this dispute in the judgment today. But it's one of those areas, and I have in mind that your lordship has in other cases asked for expert evidence on issues of practice of UA law. And there may be issues as to the effect, the meaning and effect of the divorce decree. And you've heard some of those issues raised today. And secondly, the procedure by which it was obtained in this particular form.
Well, I think what I would want to do is to say that if any party wants to produce expert evidence once the pleadings have been dealt with, then it should be an application should be made to the court on paper, and I can deal with it on paper as to whether or not that's necessary in the light of either what I've said or in the light of the issues that are raised.
Thank you.
There's no doubt at all in my mind that if there are real issues of UAE law, I would want to have assistance with that. And I benefit, contrary to the practice in arbitration, I think there is benefit in having experts and not advocates. Because advocates can say within the bounds of their responsibility to the court, which is not always observed by foreign lawyers in the way that it is by English lawyers, can say what they like. Whereas an expert, he's getting an oath as to this is what his true view of the law is in practice. So I think there's something to be said for that.
Yes.
So if we need UAE law, and I don't know whether we do or we don't at this stage, we'll see. That's a matter that will have to come back before the court.
Thank you. As to the timing of that application, I suppose we would say that application.
Now let's wait and see what Mr. Taylor has to say about timing generally.
I had estimated 2 days for trial.
Yeah.
And the idea of these directions was to try to get us to the position where we've completed all pre-trial steps by Christmas or by the end of the year. Now that may be tight. It depends on who's available and who can deal with production requests and all the rest of it. But if that was achievable, we could be looking for a 2, possibly 3, given what's happened today, day hearing in January or February. And that really is what we're endeavouring to produce.
Mr. Taylor?
My lord, I mean, I'm not going to push back too hard on time limits. I think, bearing in mind that, I mean, obviously this will want to be harmonised so far as possible with timelines that the second defendant is under. I'm wondering whether if one could just push it to 21 days at the first hurdle. And I respectfully agree with your lordship about expert evidence. I think that this is something where it's more likely than not that it would be a benefit. That there should therefore be a short window, I imagine, after the close of pleadings, in which either parties would come forward with experts or not. You're mute, Mr. Montague.
Sorry, I think His Lordship's proposal is that there is a period within which either party may apply for permission to adduce expert evidence, and clearly we need a decision on that, because everyone needs to know where they stand as to whether they need experts. So I was going to suggest that perhaps within, say, 7 days of the defence, any party wishing to rely on expert evidence should make that application.
Yes. Yeah.
No later than. I suppose one might want to apply for it before.
Yes.
If it's going to be pleaded extensively, it's that
well, indeed, it may be obvious to, once you've pleaded your case, that's or the second defendant's pleaded her case, that's what what's required. But within 7 days, any application for expert evidence to be made to the court, and response to that application within 7 days thereafter, and the court will deal with it on paper unless it feels it necessary to have a hearing.
Thank you.
Yes, then document production. What do you say, Mr. Taylor, about the other timelines in class 2, 3?
Look, given that there has been some document production already in the commercial court, I think the parties should be subject to a fairly brisk timetable. I'm not going to.
And you have more time on your hands than you used to.
I wouldn't run away with thinking that, Your Honour. I've now demoted you again, my lord.
All right. And how long do you think for trial?
I think 3 to 4 days. If there's, I mean, I think it does depend on whether there are experts, because I think you can see experts being cross-examined for a day each, frankly, can't you?
Well, I wouldn't go that far, but it
seems
to me
it was more than half a day on each expert, to be frank.
Yeah.
It depends on how many witnesses my learned friend has, I suspect.
Yes.
I don't, sitting here, I don't know, but I would have thought 3 to 4 days.
Well, it's safer to err on the cautious side in terms of provision of a date. It's not going to make a lot of difference. I mean, I don't know whether the plan is that I should hear this or not. Owing to what appear to be fairly recent developments, I'm the first port of call, so to speak, for everything in the quote civil or commercial line, as I understand it, and unless I say I can't do it, and then it goes to one of a range of other people. I think that's how it works, but you two may know more than I do about the system.
If Mr. Montague Smith is shaking his head, then
no,
I'm shaking mine even harder.
But
you don't know.
We're not in the Dubai Economic Court or the arbitration court, so no. But I'm not aware of any other amendments or changes that your lordship's alluding to. But I mean, in any event, we're very content if your lordship has a time that works in January or February for a 3 to 4 day hearing, then that would be
for reasons best known to the authorities. I am head of the division of the Civil and Commercial Court,
Ah,
in
well, congratulations,
in the DIFC,
whatever that means.
whatever that means. And the job was put to me on the basis that it didn't involve any additional work of any magnitude, but that basically I was the first port of call, so to speak, for cases, and I would be told what the options were, but I don't think I actually have necessarily the power to allocate it. It's all a question of who's available to do anything, and there are plenty of other judges who are capable. Was to give you some indications of availability in case it helped you, that's all. As matters currently stand, yes. Well, I've got a bit of room in the last week or so of January, and a bit of scope in not too bad in February as matters stand at present. So that there ought not to be a great difficulty in finding a 2, 3 or 4 day period in January, February. It's all a bit iffy after that, but
yeah, thank you. The directions that we've been discussing, it seems to me, will likely get us to conclusion of that by the end of the year. But I mean, it probably is worth not booking enough trial immediately after, just in case. So February seems to me to be the best place to put it. I'm relatively clear myself. In February, I haven't taken instructions from my solicitors, but I suspect that they would want to get on with it as soon as we reasonably can. And I'll get a WhatsApp if anyone has a particular problem. But my suggestion would be that we simply book in 4 days now, if your lordship has the ability to do that.
But I have the ability without liaising with the court, but I can tell you what I can do, and the court can then come back to you and tell you if that's workable from the court's perspective.
Of course.
I mean, what I'm seeking to do, I make no bones about this because I've said so. Cases that last for a day or two, I'm happy to do virtually. Cases that go for longer, I much rather do in person. I think there's a real benefit, and certainly where assessment of witnesses is important, which probably would be the case here, one would be looking for an in-person hearing rather than a virtual one.
Yes, I can see the sense in that, and I was thinking along the same lines.
I'm not everybody takes the same view about witness demeanour and so on and so forth, but I'm an old-fashioned judge, and I like to see how the witnesses respond and so on and so forth. And plainly, credibility is going to be an issue here, isn't it, Mr. Taylor?
Plainly, yes, my lord.
Yes. Right. Well, as matters stand, what's that? Matters stand, I think I could do either the week beginning the 6th of February or the week beginning the 13th of February.
I have a very slight preference for the 6th, simply because the 13th is a half term, but it needn't get in the way if others can't do it.
Mr. Taylor?
I have no particular obstacle to either. Wouldn't want to interfere with Mr. Montague Smith's half term or St. Valentine's Day necessarily, but
we're a little past Valentine's Day. It's definitely half term these days.
Well, let's say the week of the 6th, provisionally, and we'll ask the court if they're happy with that, and work towards that with the timetable as discussed.
Well, this is plainly provisional for both the reasons as you've just mentioned, and to the extent that the second defendant and their advisors have got to fit in. So if in the short term those two sets of February dates that are there, it would be helpful, I think.
Understood, but I mean, to whatever else may be the position, the two defendants' positions, so far as trial dates are concerned, are going to be essentially coextensive, one would have thought, you know, in terms of, I can't see any obvious reason why they should be different other than personal commitment. But yes, Galadari will have to be brought into the equation, self-evidently. But let's provisionally work on that basis.
So, my lord, you're saying provisionally work for the 6th?
Yeah. All right. Now, you're going to work out the interest and try and agree all that between you. What else needs to be discussed at this stage?
Assume costs.
Yes, okay. Assume that I will write something this afternoon, so you won't get your reasons until next week by the time it's been through the court system. But otherwise, as you say, costs are probably the only other outstanding issue, and you can be exchanging draft order, which can then be finalized when the reasons are produced.
Yes, thank you. So I will put together a draft order of the substantive parts and also of the directions.
Please.
There's an issue as to the principle of the costs, and obviously I asked for my costs of all of the applications that have been made and of the action insofar as it relates to the first defendant. But we can leave that to that aspect to one side if we like. It's the applications that are the most important for today. But we don't have time to deal with costs going forward. So I was going to ask you for a payment on account, but perhaps we can just write to you if we can't agree something.
All right. Yes. Well, there are a whole lot of other people lining up for their costs before you, Mr. Montague-Smith.
We've already got some costs in our favour and didn't get us very far so far, but
no, that's what I meant. I was thinking of the claimants in the UK and the solicitors there. Anyway, there we are. Yes, all right. Costs. I've got a schedule somewhere, have I? And am I expected to assess this now? And
no, I don't think. I'm not sure you do have a schedule at this stage, but in principle, I asked for my costs and I asked for a principal order in relation to that. And I was, as I say, I was going to suggest that we simply, if we can't agree a payment on account being ordered, that we simply write to you and say, yes, here's the schedule and I'd like 50% or whatever it may be. Sorry,
yes, I missed what you said on that. Yes. There's nothing you can say about that, is there, Mr. Taylor?
Not a great deal, my lord. It seems sensible, and I also have a residual concern about whether there may be something substantive to decide with respect to the interest, because my lord made exactly the points that I would have wanted to make about it not remaining simple interest because you're just continuing the obligation. But whether it becomes one currency, what the consequences are there, I haven't had a chance to see what the differential rates of interest are or what the consequences would be if it was converted in its entirety into dirham.
Well, I can't see any reason why it would be converted into dirhams on the face of it.
Well, I think, my lord, that certainly makes things easier if because you would.
Well, it must be right, mustn't it? Because the judgment was we're dealing with recognizing an English court judgment that's been expressed in specific currency terms for the damages and currency terms for the costs. Obviously, any order that I make for costs may be in different currency. But other than that, it will be just as the judge ordered it in the UK, and he didn't order any compound interest or anything of that kind. So it will be just simple interest that continues.
That's enormously helpful, my lord, because what's inherent in that is that well, apart from the judgment, unless there's a cut-off for the English judgment interest stopping to run, is that you've dealt with the first thing, which is you've got to harmonise the rates and the amounts because it's only one judgment. But plainly anything that is satisfied, anything that is paid in satisfaction, this judgment counts towards satisfaction of the English judgment as well, because there's only one set of interest, because there's only one debt with one citizen. I think I just wanted to have that discussion in case.
Yeah, no, and the way I think, I can't remember quite what I've said before, and I may have said something different, but the reality of it is when you're recognizing the foreign judgment, and if you are dealing with it in the same currency, what you're going to do is say the judgment is for this sum as at the same date as the English judgment. You're not going to have a fresh judgment as at today's date at all. It'll simply be a judgment that reflects in terms the English judgment. So there's no question of any duplication or anything of that kind. The only other point, as I say, will then be the costs. And on the face of it, you've disappeared. Are you still there?
I am still here. Apologies that I suddenly low power mode had popped up rather alarmingly on my iPad. I just plugged it in.
Good idea.
No, I follow that, sir, and one doesn't have.
Right, so no
foreign compensation. Good.
Claimant entitled to its cost of these applications, and quantum to be the subject of detailed assessment if not agreed. Interim payment to be made, once again to be the subject of decision by the court if not agreed.
Thank you, my lord. Yes.
I think that takes us as far as we could possibly go.
Thank you very much.
Yeah, right. Well, that's it. All right. Thank you both very much, and you will liaise with Galadari over the directions because they will need to be brought in to make sure they have no objection.
Yes.
All right. If you would like to sign out, I'll have a very quick word with the associate, and I apologise now to all the staff if we've kept them later than we should, but I blame Mr. Taylor.
Everyone does, my lord. Thank you.
You've got.
Thank you very much, my lord.
You can take it.
We'll log off. Thank you.
All right. Thank you.